are to pay $180 restitution to DPS for the lab fee. That appears to be your plea agreement, Mr. Davis. Is that correct?
Yes, sir.
Is that it, Mr. Knoll?
It is, Your Honor.
That's your recommendation, Ms. Anderson?
Yes.
All right, I'm going to identify the plea documents, Mr. Davis. We have your plea agreement, 9 years with credit for time served in TDC, restitution amount of $180 to DPS for the lab test. Second documents and acknowledgement of admonishments. Admonishments are just explanations. They do give you that full range of enhanced sentencing, 2 to 20 and a fine of up to $10,000. There's a total of 7. Right below the 7th one, there's a signature on the line above where it says defendant. Is that your signature? Can you see it?
Yes, sir.
It's also signed by your attorney, Mr. Knowles. So do you understand also 7 of those admonishments, which are just explanations?
Yes, sir.
Next document we're going to, signed by you and Mr. Knoll, approved by Mr. Anderson, by Ms. Anderson, but I got to be careful, is a waiver of trial by jury. You understand you're waiving, giving up your right to a trial by jury?
Yes, sir.
You're asking the court to hear your case and follow the state's recommendation on your plea of guilty on the sentence without a jury. Is that correct?
Yes, sir.
Your next document, you're waiving confrontation with witnesses and agreeing to stipulate testimony. That stipulation of testimony is in the next document. It's called a stipulation of evidence. It's stage 2. It's signed, and now I've sworn you to it. Also signed by Mr. Knoll. Do you understand that stipulation of evidence is a signed and sworn to written judicial confession under oath by you to all the allegations in the indictment and the enhancement paragraph? Do you understand that?
Yes, sir.
Then you've agreed to stipulate testimony. You're waiving, giving up your right to appeal, and waiving, giving up your right to file a motion for new trial. That's in a document signed by you and Mr. Knoll. Do you understand that?
Yes, sir.
Of course, you've waived the pre-sentence, and the court's done that. So we're going forward without a pre-sentence. And there's a trial court certification going up. You'll see it. It is the document I was referring to. You can see where it says, but signed by you and Mr. Knoll, but you see where it says under 4, this is a plea bargain case. So if you plead guilty, I'm going to follow the plea agreement that says 9 years in TDC with credit. And then you understand you're also waiving, giving up your right to appeal. Do you understand that?
Yes, sir.
All right. So understanding all these plea documents, do you still wish to go forward on your plea of guilty to the indictment?
Yes, sir.
All right. I think I need to be sure that I get your plea of true to the allegations in the second paragraph. I got off on all the plea documents. So just to be sure, I'm going to read the allegations in the second paragraph. I'm going to ask you whether or not your plea is true or not true. It's further presented prior to the commission of the charged offense. That's the offense charged in the first paragraph. It's alleged on the 20th day of December, 2018 in cause number 114-1301-18 in the 114th Judicial District Court of Smith County, Texas, has alleged you were finally convicted of the felony offense of possession of a controlled substance. Are those allegations true or not true?
Yes, sir. It's true.
Are you entering your plea of true to these allegations freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Court receives and accepts your plea of true, finds it was entered freely, intelligently, knowingly, and voluntarily, and now your full range of sentencing has just been enhanced. It went from 2 to a maximum of 10 years up to 2 to a maximum of 20 years, fine of up to $10,000. Do you understand all that?
Yes, sir.
All right, now we've gone over your plea agreement, which I'm going to follow. I'm going to set your sentence at 9 years in TDC, as I've already said a couple of times, with credit for time served, ordered restitution. You've been over and gone over with Mr. Knoll your admonishments that I've covered with you, the 7 admonishments. You've waived giving up your right to trial by jury, waived confrontation with witnesses, signed and sworn to a stipulation of evidence. It's a judicial confession. Agreed to stipulate testimony, and agreed to waive your right to appeal, and agreed to waive your right to file a motion for new trial. Do you understand all that, Mr. Davis?
Yes, sir.
All right, let me be sure I've got this in on the second paragraph. It alleges, it may already have, but I got off on all the plea papers. It's further presented prior to the commission of the charged offense that on the 20th day of December 2018 in cause number 1301-18 of the 114th District Court of Smith County, Texas. It's alleged you were finally convicted of a felony offense of possession of a controlled substance. Are those allegations true or not true?
It's true.
Are you pleading true, freely, intelligently, knowingly, and voluntarily?
I'm pleading guilty.
Court then does receive and accept your plea of true, finds it was entered freely, intelligently, knowingly, and voluntarily, finds the allegation of the second paragraph of the indictment to be true, enhances your full range of sentencing up to not less than 2 and more than 20 years and a fine of up to $10,000. Now I'm going to go, you understand all the allegations, we've been over this, you understand all the allegations on the charge in the indictment, your plea agreement, that you understand all these plea documents you signed or signed and sworn to, is that correct?
Yes.
All right, I'm going to go over some questions now, pretty straightforward. Just to be sure I've covered them, you do read, write, and understand English, correct?
Yes.
You have not consumed any alcohol in the last 24 hours.
No.
You're not under the influence of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system, correct?
Correct.
You've never been in a mental institution or under psychiatric treatment, correct?
Correct.
Do you understand everything you're doing in court today?
Yes.
And you've been over everything with Mr. Knoll, correct?
Yes.
And he is competent, Mr. Knoll, correct?
Believe him to be competent, Your Honor.
Thank you. Any evidence of incompetence, Ms. Anderson?
No, sir.
All right, now, Mr. Davis, we're going to take your plea now, understanding all the allegations, the charge in the indictment, all of your plea documents, the full range of sentencing, and your plea agreement with the state. What is your plea today to the indictment in cause number 241-1442-21 to the offense of possession of a controlled substance as alleged in the first paragraph, which has been enhanced to a full range of sentencing of a second-degree felony as a result of your plea of true to the second paragraph? Is your plea guilty or not guilty?
Guilty, sir.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No, sir.
Are you entering your plea of guilty to this indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, sir.
You're not entering this plea of guilty because you have some delusion in your mind or unrealistic hope of pardon, parole, or leniency, are you?
No, sir.
Court does receive and accept your plea of guilty, finds it was entered freely, intelligently, knowingly, and voluntarily. The court does find you guilty of the offense of possession of controlled substance as alleged in the first paragraph, enhanced up to a second-degree felony based on your plea of true to the second paragraph. Okay, Ms. Anderson.
We offer states 1, the plea packet with signed waivers and admonishments. States 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
With no objection, Mr.
No objection, Your Honor. No objection, Your Honor.
States Exhibit 1, all the plea documents. States 2, the signed, sworn to stipulation of evidence. States 3, all approved by the court, admitted into evidence. The court does find the defendant's waiver of his rights. All the other documents signed or signed, sworn to by the defendant were all done freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this cause number enhanced to a second, to the offense enhanced to a second-degree felony was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily. Court in this case, based upon the defendant's plea of guilty to the offense alleged in the indictment, enhanced to a second-degree felony, finding it was entered freely, intelligently, knowingly, and voluntarily. Court does find the defendant guilty of the offense, possession of a controlled substance alleged in the first paragraph of the indictment, enhanced up to a second-degree felony, moving to sentencing.
We offer states 4, an electronic copy of the written discovery in this case. We'll deliver it to the court upon the conclusion of the Zoom hearing today.
No objection, Your Honor.
With no objection, Mr. Knoll, court does in this case, based upon the defendant's plea of guilty to the offense alleged against him by the state in its indictment, possession of a controlled substance, enhanced to a second-degree felony, and the evidence presented and admitted into the record by the court does find the defendant guilty of the offense alleged against him by the state in its indictment, possession of a controlled substance, a third-degree felony, which is enhanced to a second-degree felony. Court follows the plea agreement, the recommendation of the state assessed to the sentence in the case at 9 months in the Texas Department of Corrections Institutional Division. That's assessed with credit for time served Restitution is ordered as a part of the sentence to be paid to DPS for the lab fee analysis of the controlled substance. Sentence is formally pronounced. Mr. Davis, do you understand? I covered it earlier, but do you
Yes, sir.
understand? You signed a document that waives, gives up your right to appeal. Do you understand that?
Yes, sir.
There's also another document that you signed, Mr. Knowles signed them also, waives, gives up your right to file a motion for new trial. You understand that?
Yes, sir.
Are you presenting those waivers to the court now through your attorney, Mr. Knowles?
Yes, sir.
All right, be the order of the court then, Mr. Davis, the court having formally pronounced sentence that, and following the recommendation at 9 months in the Texas Department of Corrections Institutional Division with credit for time served and restitution. Of course, you'll be continued, Mr. Davis, in the Smith County Jail until such time as you're transported to the Texas Department of Corrections Institutional Division, a unit thereof, to serve the 9-year sentence assessed by the court with credit for time served, restitution order to DPS. Your credit for time served, unless there's some other jail you've been in, the credit for time served I've been referring to is the credit you have for time served in the Smith County Jail. Do you understand all this?
Yes, sir.
Anything else, Mr. Noel?
No, Your Honor.
Anything else, Ms. Anderson?
No, sir.
All right, we're in recess, counsel. Defendants continued in custody, they can be transported to TDC, serve the sentence for credit for time served in the Smith County Jail.
Thank you, Judge.
Thank you, Mr. Noel.
Hey, Clifton.
Good morning.
It's good to see you. One more week.
I'm here.
We're glad.
Don't admit any more than that, Mr. Roberts.
Okay, Judge.
Ms. Anderson will try to take advantage of you if you start admitting too much.
No, she got a sweetheart. She wouldn't do that, Judge.
I want that on the record.
I hope we're being broadcast.
We can mess that up if you want me to get each Sanders down here. All right.
We need Kenneth Boland.
Someone tell them we need Kenneth Boland.
She's going to get it.
Guy's gone to get Kenneth.
All the same.
I'm sorry.
They're all the same.
Okay.
Please.
All right, here comes Mr. Boland. Bowling, B-O-W-L-I-N. There's 3 cause numbers. Allstate versus Kenneth Bowling, who's before the court with his court-appointed attorney, Mr. Roberson. Ms. Anderson, State's counsel's present. Court's probation officer's present. 241-1610-21, State versus Kenneth Bowling. That's on a burglary of a building, state jail felony. 241-1609-21, State versus Kenneth Bowling. That's on indictment for unauthorized use for motor vehicle, state jail felony. Cause number 241-1608-21, State versus Kenneth Bowling. It's on indictment for possession of controlled substance, state jail felony. You want to waive the reading presentation of all 3 indictments and all the other formalities, Mr. Roberson?
Judge, wait the formal reading of the indictments in all 3 cases, name correctly set forth in all 3 cases. He knows the range of punishment. He's going to change his plea from not guilty to guilty. Also, Judge, he's waiving mandatory probation in cause number 241-1608-21.
Now, Mr. Bowling, did I get you sworn in? I was reading the plea papers.
Oh, sir.
Raise your right hand. You solemnly swear the testimony you'll give in the cases now before the court will be the truth, the whole truth, and nothing but the truth?
Yes, sir. So help me God.
All right, thank you. The 3 cause numbers we have are 241-1610-21, State versus Kenneth Bowling on the indictment charging burglary of a building and state jail felony. The next cause number we have is 241-1609-21, unauthorized use of a motor vehicle. That's a state jail felony, State versus Kenneth Bowling. Third case is cause number 241-1608-21, possession of controlled substance less than a gram, another state jail felony. Now we've got a series of plea documents in all 3 of these cases. They're basically the same plea documents. they just vary obviously according to the allegations in the indictment. In each case, we've got the indictment, which I just identified. They've been going up on the screen. In each case, I have a set of plea documents. These are the set of plea documents I have in each case. Of course, I've got the indictment, obviously, in each case. You've been over all these three indictments with Mr. Clifton Robertson, so you understand the allegations. Is that correct, Mr. Bowen?
Yes, sir.
Now, the first case up, 1610-20, agreed punishment recommendation. And I've got these, the plea, obviously, I've probably said this twice, but the plea documents vary, obviously, according to the allegations in the indictment. But each one of these cases has an agreed punishment recommendation in it. The first one's up on the screen. You can see it. If you enter a plea of guilty to the indictment charging you with burglary of a building, State Ms. Anderson is going to recommend your sentence at 13 months in a state jail facility. Do you understand that? Because that's also will be assessed with credit for time served. Each one of these three sentences are going to be ordered to run concurrently at the same time with credit for time served. Do you understand that?
Yes, sir.
So in 241-1610-21 on the indictment, for burglary of a building, you understand if you enter a plea of guilty, Ms. Anderson is going to recommend 13 months in a state jail facility. I'm going to follow that recommendation, assess 13 months in a state jail facility. That'll be assessed with credit for time served. You understand that one?
Yes, sir.
Let's go on over here to the other one. It's another state jail felony, 241-1609-21, unauthorized use for motor vehicle. That's state jail felony also. Sentencing range, not less than 180 days to more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. In that one, the state's going to recommend your sentence at 13 months in a state jail facility, and I'm going to follow that. Then on down in 241-1608-21, that's state jail felony, possession of a controlled substance. I'm going to follow the plea agreement on that and assess the sentence at 13 months in a state jail facility. All three sentences are assessed by the court following your plea agreements, the documents you and Mr. Robertson have signed in all three cases, along with Ms. Anderson. The court's following the plea agreements in each one of the three cases and will pronounce the sentence at that term that's agreed to by the state and defense in each one of the three cases. Do you understand that?
Yes, sir.
Did I get you sworn, Mr. Bowling?
Yes, sir.
Yes, okay. Sometimes I rush past that.
I understand.
I'm going to go through and identify all the plea documents in one of these sets of cases. Obviously, they vary on the allegations in the indictments. Then the stipulations of evidence reflect that you've already signed and sworn to a stipulation that you committed the offense charged in each one of the three indictments. There's a stipulation on each one of them. But 241-1610-21 on the burglary of a building, if you enter a plea of guilty to it, being a state jail felony, 180 days up to 2 years, Ms. Anderson is going to recommend your sentence at 13 months in a state jail facility. That'd be assessed with credit for time served. The 13-month sentence would be ordered to run concurrent with the other two sentences. You would be ordered to pay restitution due in this cause number 241-1610-21 for the burglary of a building, and that restitution will be determined after I pronounce the sentence by our probation department in each one of the three cases. Do you understand that?
I don't know what that means, actually.
Well, that's understandable. Marcel explained to him. Is that Marcel?
One of those had a lab fee written on it. I didn't know if that's what that meant, but
Let me see. Let me see if I should be able to explain restitution to you and what that means. In each one of these three cases, what will happen is if you do plead guilty, and I'll follow the plea agreements and assess the sentence recommended by the state. But in these cases, I don't know right now whether or not, I know that in the burglary of a building for state jail felony, you're going to you're going to be ordered to pay $180 to the, is there restitution due on these, Ms. Anderson? I better ask you.
Your Honor, I'm not aware if there's restitution. It's going to have to be determined post-sentence if there
Okay.
is.
What that means, Mr. Bowling, I'm not seeing a restitution figure in here, which is normal. After I follow the plea agreements and assess the sentence, the probation department their department that determines restitution will look into each case and determine if you owe any restitution to the victim for commission of the offense. Now, if they do, then I'll order that to be paid as a part of your sentence. That's what that means. I just don't have the figures right now. I don't know right now whether or not there is any restitution. The reason for that is we didn't do pre-sentence investigation. But do you understand what we're talking about?
Yeah, I hesitate to sign something that's going to be later figured and put on a paper.
Well, you know, that is actually what would happen now. If you want to, you know, I can order it and the probation department can examine each case and determine what restitution, if any, is due in each one of the three cases. I have no earthly idea.
I don't mind going forward.
Okay,
I know that if I did cause any damage, that I would like to pay for it. I just hesitate because you know, it's just, I don't know what would be put on there, but that'd be okay.
That's a good question because I don't know either. So I have to order restitution in the amount determined by the probation department by a post-sentence investigation. That will be after I follow the plea agreements and sentence you to the state jail time that's on each plea agreement. It's a good question. If I'm go ahead and take the pleas, I can't tell you today what the restitution is myself.
I understand. Yes, sir.
Okay. All right. Let me go see if I can sort of get back on track now. You do understand all these plea documents you signed or signed and sworn to in all three of these cases. Is that correct?
I believe so. Yes, sir.
Okay. And you understand to be sure you understand it in 241-1610-20, State versus Kenneth Boland for burglary of a building. That's a state jail facility. That's a state jail offense to which you'll be sent to a state jail facility. The full range of sentencing on that one's 180 days up to 2 years in a state jail facility. The state's attorney, Ms. Anderson, has recommended 13 months. I'm going to follow it. Says 13 months in a state jail facility on that burglary of a building with credit for time served. Then restitution will have to be determined. Are you with me on that one?
Yes, sir.
All right, the next one's on this unauthorized use of a motor vehicle. That's a state jail felony. That's 241-1609-21. When your plea agreement on that one, it'll be pulled up on the screen. It's for the same time.
Yes, sir.
State's if you do plead guilty, I'm gonna follow the recommendations, says you sentenced at 13 months in the state jail facility, and you can see right under it, it says a special condition of the recommended sentence being payment of restitution in the amount to be determined by a post-sentence investigation.
Oh, I see. Yes, sir.
That means I don't know what it is.
Gotcha. Yes, sir.
Okay, then in the next case is the same situation, 241-1608-21, state jail felony possession of a controlled substance. That one I can tell you the restitution is $180 for analysis of the controlled substance.
Okay. Yes, sir.
Right, so we'll go on through now. Since you do understand all these plea documents and all your plea agreements, we'll go ahead and proceed on your pleas to all three indictments and get those done, and then I'll come in and formally pronounce the sentence following the plea agreement. So these are my questions to you. Be sure you understand my questions to you are for your pleas, what appear to be going to be your pleas of guilty to the indictments in all three cause numbers. You understand that?
Yes, sir.
And you understand all your plea documents you signed or signed and sworn to, and the full range of sentencing in all three cases. Is that correct?
Yes, sir.
Here are the questions. They apply to your pleas in all three cause numbers. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcohol in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
Yes, sir.
Okay. How long ago was that?
I was young, sir.
Okay, that's so safe to say right now, you're not under any type of psychiatric treatment or taking any type of medications for any condition. Is that any psychiatric?
No, sir.
Is that answer no?
No, sir.
All right, do you understand everything you're doing in court on all three cases?
Yes, sir.
Have you been over everything about the facts of all three cases and all your plea documents on all three cases? And what you're doing today in court by Zoom on all three cases?
I believe so. Yes, sir.
All right, is he competent, Mr. Roberson?
He is, Your Honor.
Any evidence of incompetence, Ms. Anderson?
No, sir.
All right, again, in all three cases, the court does note State's counsel signed her consent and approved of the waiver of trial by jury. The court approves the waiver of trial by jury. All the other waivers in all three cases signed or sworn to by the defendant, signed by his attorney. All right, now, these questions are being asked now as the others for purposes of your pleas, which appear to be you're going to go forward and enter pleas of guilty to the indictments in each three cases. So these are the questions I have for you now. Do you understand all the allegations and the charge in each one of the three indictments against you?
Yes, sir.
Do you understand the full range of sentencing and all your plea documents you signed and sworn to in all three indictments?
Yes, sir.
Do you have any questions for me about any of the plea papers or anything we've gone over in any one of these three cases or all of them? In other words, do you understand everything we've been over?
Yes, sir.
And you understand all these plea documents and your plea agreements and everything you signed?
Yes, sir.
And you've been over all that with Mr. Roberson. He's signed them also. Is that correct?
I believe so. Yes, sir.
He's on each one of them. All right. I'm going to go this one by one now. And calls number 241-1610-21. What is your plea today to the indictment charging you with burglary of a building, a state jail felony?
Guilty.
In cause number 241-1609-21, what is your plea today to the indictment charging you with unauthorized use of a motor vehicle, a state jail felony?
Guilty.
In cause number 241-1608-21, what is your plea today to the indictment charging you with possession of a controlled substance less than a gram, a state jail felony?
Guilty.
All right, now, are you entering your pleas of guilty to the indictments today in all three cases because you are guilty of the offense charged in the indictment in all three cases and for no other reason?
Yes, sir.
Has anyone threatened you in any way, promised you anything, or coerced you to enter a plea of guilty to any of the three indictments?
No, sir.
Are you entering your plea of guilty to the indictment in each one of the three cause numbers today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment in each cause number?
Yes, sir.
Are you entering your plea? Listen closer to this one. Are you entering your plea of guilty to the indictment in any of the three indictments as a result of any type delusion in your mind or any type unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your guilt. Court does receive and accept your plea of guilty to the indictment in each one of the three cause numbers. Go ahead, Ms. Anderson.
In each cause number, we offer states 1, the plea packet with signed waivers and admonishments, states 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
No objection. In each cause number, the court admits into state's evidence, state's exhibit 1, that's all the plea documents in all three cause numbers, signed or sworn to by the defendant, signed by his attorney. Admits into evidence states 2 in all three cause numbers. Those are the written stipulations of evidence, signed or sworn to by the defendant in all three cause numbers. And the court approves and admits into evidence in all three cause numbers all of the discovery information which the state has filed in the record. Those are all admitted in with no objection. The court, having admitted into evidence, states exhibit 1, 2, and 3 in all three cause numbers, all the plea documents and the plea agreements in all three cause numbers, having been admitted into evidence and discovery compliance is approved by the court and admitted into evidence in all three cause numbers. Further, what's referred to as states 2 is you signed and sworn to be sure you understand it. You signed and sworn to those stipulations of evidence, states two in each one of the three cause numbers. Those are the ones that are written judicial confessions under oath by you to the charge in the indictment in each of the three cause numbers. You understand that?
Yes, sir.
And you signed and swore to each one of those stipulations of evidence, the confessions, freely, intelligently, knowingly, and voluntarily. Is that correct?
Yes, sir.
And then further, the court, having approved the States Exhibit 1 and all three cause numbers, States Exhibit 2 and all three cause numbers, court submitted into evidence States 3 and all three cause numbers, the discovery compliance. The court, having admitted into evidence and does admit into evidence in each one of the three cause numbers, States Exhibits 1, 2, and 3, the court does find the defendant's waiver of his rights executed of all the other documents in all three cause numbers were done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find in all three cause numbers that the defendant's plea of guilty entered to the indictment in all three cause numbers, each of the three cause numbers, was entered by the defendant to the indictment in each one of the three cause numbers, freely, intelligently, knowingly, and voluntarily. However, the court finding the evidence on the defendant's plea of guilty to the indictment in each one of the three cause numbers is fully sufficient to support the defendant's plea of guilty to the indictment in each of the three cause numbers. The court does move forward and find the defendant guilty of the offense alleged against him by the state in each of the indictments in each of the three cause numbers. Finding his pleas of guilty to those indictments are all entered freely, intelligently, knowingly, and voluntarily. Have we gotten to sentencing? Have you got your sentencing in on all three?
No, Your Honor, but I will admit at this time a single copy of States 4 that contains written discovery for all three cases.
No objection, Your Honor.
Now that's States 4 in all three cases, Mr. Bowling. That's what we call the discovery information. It's got all the offense reports in it for each three cause numbers, any video evidence or whatever evidence the state's got it. They've offered it in under States 3, and I'm admitting discovery compliance forms and into evidence for purposes of all three cause numbers. Anything else, Mr. Roberson?
No, Your Honor.
All right, the court then in this case, based upon the defendant's pleas of guilty to the indictment in all three cause numbers and the evidence presented and admitted into the record by the court on the state's offer in all three cause numbers, the court does find the defendant guilty of the offense alleged against him by the state in its indictment in all three cause numbers. That is, the court does find the defendant guilty of the offense of burglary of a building, state jail felony, as alleged in cause number 241-1610-21. The court does find the defendant guilty of the offense of unauthorized use of motor vehicle, state jail felony, in cause number 241-1609-21. And the court does find the defendant guilty of the offense of possession of controlled substance, state jail felony, as alleged against him by the state in its indictment in 241-1608-21. And the court does follow the plea agreements and the recommendations of the state. The court does assess the sentence at 13 months in a state jail facility in 241-1610-21 for the offense of burglary of a building. The court does assess the sentence following the plea agreement in cause number 241-1610-21 at 13 months in a state jail facility, assessed with credit for time served, or to run concurrent with the other two sentences. In cause number 241-1608-21, court having received and accepted the defendant's plea of guilt, of course, as the court has in the other two cases, the court does find the defendant guilty of the offense of state jail felony possession of a controlled substance as alleged in the indictment in that cause number. And the court does assess the sentence in that cause number at 13 months in a state jail facility. The court, having followed the plea agreements, assessed the sentence recommended by the state and agreed to by you, Mr. Bowley, and your attorney in all three cause numbers. The court does formally pronounce sentence as dictated by the court. And Mr. Bowling, in each one of these three cause numbers, do you understand you and Mr. Roberson in each of the three cause numbers have filed a written waiver giving up your right to appeal, and filed a written waiver giving up your right to file a motion for new trial in all three cases? Do you understand that?
Yes, sir.
All right, be the order of the court, then you'll be continued in custody of the sheriff, Mr. Bowley, until you can be transported to a state jail facility to serve the 3 sentences assessed by the court following the plea agreements in all 3 cause numbers. Each sentence assessed by the court is ordered with credit for time served, and each sentence assessed by the court following the plea agreement in each cause number, all 3 sentences are ordered to run concurrent or at the same time with credit for time served, because all 3 sentences have been conducted in the same cause number, in the same hearing, all 3 cause numbers in the same hearing. Waivers of appeal, waivers of right to file a motion for new trial, received and accepted by the court, presented to the court through Mr. Roberson, also signed by the defendant in each one of the 3 cause numbers. So, Mr. Bowen, you'll be in jail. You'll be building up credit while you're from now on, as well as your past time in the Smith County Jail. Then the sheriff's also get you to the state jail facility as soon as they can, where you've been ordered by the court following the plea agreements and the judgments to assess the sentence agreed on in each one of the 3 cause numbers. They all run at the same time. They're all assessed with credit for time served. Your waivers of appeal are all accepted. Are you satisfied with the legal representation provided by Mr. Clifton Roberson?
Yes, sir. There was hope that well, yeah, he explained everything properly, and I think that he did his best to make sure that I got a fair judgment.
Well, he's done a good job, and he usually does an excellent job. So if there's nothing further, do you have anything further, Ms. Anderson?
No, sir.
Anything further, Mr. Roberson?
No, Your Honor.
All right, the defendant is continued to the custody of the Smith County Jail until he can be transported to a state jail facility to serve the 3 sentences assessed by the court, each one of these 3 cause numbers. Again, all 3 sentences being in order to run concurrent at the same time with credit for time served. We're in recess.
Will I get a copy of that discovery?
If you get, you can get it through Mr. Roberson.
All right. Well, if he would send that over, if not, that'd be okay too. I'm sure that's.
Explain that to him, Mr. Roberson.
Judge, under the Mortgage Act, I can't let him have a copy of the discovery, but I can read over the discovery with him, Your Honor, and I read over the discovery with him.
See, he can't, those discovery documents being part of the file, he can't actually give you the documents themselves. As long as he's gone over each document with you and you understand the document,
Okay.
you're in good shape.
Yes, sir. That's fine.
It's basically what I didn't go into the details of each case because I don't really have the details, but anyway, you should be.
It's not a big deal. It's not a big deal. I was just wondering. Thank you.
All right.
Is that all that y'all need from me?
Yes,
You know, you can have him tell Charles to come in.
All right, will do. Thank you.
Eight oh 56151. I'm cold. Sit down, dude. Oh, Lord.
All right. We've got one case appears on Zoom. 241-1611-21, State versus Charles Fowler, who is before the court by Zoom, was his attorney, Mr. Clifton Roberson, before the court by Zoom. Ms. Anderson still representing the state by Zoom. Mr. Roberson, you want to waive this state jail felony unauthorized use of a motor vehicle indictment?
Judge Williams, the former reading of the indictment, his name correctly set forth in the indictment, knows the range of punishment, what he's charged with, gonna change his plea from not guilty to guilty. And Judge, it was a situation where he was offered 3 years deferred. However, my client did not want the 3 years deferred and opted to sign for 7 months in state jail facility with credit for any time in the Smith County Jail.
When I assessed the 7 months in a state jail facility, It'll be assessed with the credit he has for time served in Smith County Jail.
Yes, Your Honor.
Okay, Mr. Fowler, raise your right hand. Can you hear me? You solemnly swear the testimony you'll give will be the truth, the whole truth, and nothing but the truth, and that all these plea documents which show to be signed and then sworn to by you under oath are being sworn to by you now under oath, freely, intelligently, knowingly, and voluntarily.
Yes, Your Honor.
Mr. Fowler, have you gone over all these plea documents with
Yes.
Mr. Roberson? I'm getting ready to go through and identify them.
Yes, sir.
All right, now, the first one going up, so you agree. First of all, you do understand all the allegations and the charge for unauthorized use for motor vehicle, which is a state jail felony. Is that correct?
Yes, Your Honor.
It carries a sentencing range of 6 months up to 2 years in a state jail facility. Ms. Anderson is going to recommend for you a sentence of 7 months with credit for time served. And appears you and Mr. Roberson have agreed to that number. Is that correct?
Yes, sir.
All right, you do understand all the allegations and the charge for unauthorized use for motor vehicle and the full range of sentencing, which is not less than 6 months, no more than 2 years in a state jail facility. Is that correct?
Yes, Your Honor.
Now, when you look at that, well, you can look at any of them, the agreed punishment recommendation or the acknowledgements. But what I need to ask you is that your signature signed Charles Fowler on the bottom of each one of these documents where it says defendant?
Yes, Your Honor.
All right, so you understand your plea agreement is if you enter plea of guilty, Ms. Anderson is going to recommend to court 7 months, and I'm going to assess 7 months in a state jail facility with credit for time served. You will be ordered to pay restitution in this case through the probation department, although you're getting 7 months in a state jail. But restitution, I don't know what it is, and I don't know if there is any. That'll be determined by the Smith County Probation Department. And then if there's any restitution, you'll be ordered to pay it as a term of your sentence back to the victim. Do you understand that?
Yes, Your Honor.
All right. In addition to your plea agreement, I've got an acknowledgement of admonishments. It gives you the full range of sentencing, not less than 180 days to more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. I'm going to follow that plea agreement, assess your sentence at 7 months in a state jail facility with credit for time served in the Smith County Jail, and you'll be ordered to pay restitution.
So,
You understand that?
So you're basically saying that I'm gonna have to pay the fine, but you're gonna give me credit of time served already. Is that correct, sir?
Run that by me again.
You're basically saying it, and how I'm listening, and I'm trying to understand what you're trying to sell me on. And you're saying that you're gonna give me 7 months time served with the credit I've been here, and I gotta pay up to a fine.
Now, I'm going to assess your sentence following you and Mr. Roberson's agreement with Ms. Anderson at 7 months in a state jail facility. The credit you will get is credit for time served in the Smith County Jail.
So I won't. So my time won't start until I go to state jail. Basically, what you're trying to sell me.
I'm sorry, sir. I didn't quite get that. Do you know what he's saying, Clifton?
I do, Judge. His time has already started. His time started when he was arrested on July the 4th of 2021. So he's getting credit from that date of arrest, Judge, and up until he goes to state jail.
Okay, so that's the way it'll work, Mr. Fowler. Apparently, I think Mr. Robeson said you were arrested on like July the 7th and booked in.
I was arrested on July the 4th of 2021, and I'm asking you. So my time has already started, so I'm already getting credit. But how you're trying to tell me is my time is stopped until I get to state jail.
No, it hasn't stopped. You're getting credit. Your time has started on July the 4th.
Okay, and how many months can you tell me have I been here, Your Honor?
You count up the days from July the 4th.
As of today, he has 130 days of jail credit.
So Ms. Anderson, your prosecutor, has determined you have 130 days credit. The way that'll work is when you're transported to a state jail facility, the Smith County Jail will send paperwork showing how many days you have credit for in the Smith County Jail, and you'll get credit for that number of days on your 7 month sentence down to state jail.
All right. So would it be possible if I do all my time here in the Smith County facility?
How long have you been there?
I've been here almost 5 months. About another week and a half will be 5 months. That's why I said that.
Well,
I only,
let me explain to you. If you do, let's say you do, and I don't know, they'll probably get you on down there before you serve the whole 7 months, but you know, they will have you, if, let's just say you sit there for the entire 7 months. Well, you're going to have to go to the state jail facility, okay? Even though you've got the time served, because they can't book you out of the Smith County Jail if you've been assigned a term in the state jail facility. If you get down there at the state jail facility and you've got 10 days left, well, let's say you do almost the whole 7 months. Well, then you'll just serve the rest of the time at a state jail, whether it's a month or 10 months or however long it is. But they have to send you to the state jail. You follow me, to book, because you got to go to a state jail and book out of the state jail. Yep, that's how it normally works.
so basically what you're telling me is I could do my whole 7 months, and until they come pick me up, I could, because I didn't see a lot of people been here for almost a year, and their time is already up, and they haven't even seen state jail.
I'll put it to you this. I have a lot of things that I have to keep up with. And I got my hands full, remembering everything I got to keep up with. That there could have been some change in that. Probably the best thing for you to do is either ask Mr. Roberson, Ms. Anderson, or ask the jail officials, okay? All I can do is pronounce the sentence at 7 months, your plea agreement in a state jail facility with credit for time served.
Judge,
It's all up to the sheriff's department and the state jail facility. They may have to transport you, book you in and out of the state jail, or that's what I think will happen. I think you'll have to go to a state jail, but I don't keep up with all of that. It's beyond what I do. You want to answer that if you can, Ms. Anderson or Mr. Roberson?
yes, Judge. Judge, he has about 5 months credit. It's going to take about a month and a half to 2 months to do the paperwork. It's a good chance that he will complete his time in the Smith County Jail, and they will PIA him out of the Smith County Jail. But they have to do their paperwork, Your Honor.
Okay, you with us on that, Mr. Fowler?
Yes, Your Honor. And
All right.
another,
Go ahead.
what happened to my other charge? Is that off my record already?
I don't know anything about any other charges, Mr. Roberson.
Talking about the misdemeanor evading charge, that we're going to be filing that in after today and proceeding on that misdemeanor downstairs.
So the state is going to file in an evading arrest charge. That sounds like it's going to be a misdemeanor. So what'll take place is if you work out a plea agreement with Mr. Roberson on that one, they'll just bring you over to a county court at law. The county court law prosecutor will make a recommendation to the judge. If you enter a plea of guilty to evading arrest or detention as a misdemeanor, it's going to be whatever time the judge gives you on the misdemeanor will run concurrent at the same time with the felony.
So after I get done with this court and this is over with, I gotta go back and I gotta wait for another court date for my evading arrest charge.
Well, I'm gonna let Mr. Roberson answer that. He's your lawyer.
And Judge, he does have a misdemeanor. The state of Texas is going to file that misdemeanor in. I would not be the attorney, but however, he'll probably get time served on that case, Your Honor, and it won't really have any effect on his felony case. He just have a conviction on his record.
Okay, you understand that, Mr. Fowler? I think that's the best any of us can do.
Yes.
All right, I've really forgotten where I was. And I'm talking about I've forgotten where I was in terms of what was my last question. So I'm just going to go back and be sure I cover all the questions with you. I don't think I'd quite gotten to them. Do you read, write, and understand English?
Yes, Your Honor.
Have you consumed any alcoholic beverage in the last 24 hours?
No, Your Honor.
Are you under the influence today of any drug, narcotic, controlled substance, toxic, going to have any of those substances in your system?
No, Your Honor.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, Your Honor.
You understand everything you're doing in court today?
Yes, Your Honor.
Have you gone over everything about the facts of your case, all your plea documents and your plea agreement and everything you're doing in court today with your attorney, Mr. Roberson?
Yes, Your Honor.
Okay, is he competent, Mr. Roberson?
Yes, Your Honor.
Any evidence of incompetence, Ms. Anderson?
No, sir.
Court of United States Counsel signed her consent approved to the waiver of trial by jury. Court approves the waiver of trial by jury All the other waivers in the case signed or signed sworn to by the defendant, signed by his attorney. All right, now, Mr. Fowler, you do understand all the allegations and the charge in the indictment against you for unauthorized use for motor vehicle of state jail felony. Is that correct?
Yes, Your Honor.
And you do understand the full range of sentencing for that offense and all your plea documents I've identified that you've signed or signed and sworn to today. Is that correct?
Yes, Your Honor.
Do you have any questions for me other than how that misdemeanor sentence will run, which has been answered?
No, I just have one other question. Do you have a release date for me, Your Honor?
Do I have a what?
A release date for me?
Oh, no, sir.
No.
No, sir, I sure don't. I don't have any earthly idea. I never know. On any defendant, when the jail will get to the defendant, either to send you to a state jail or book you right out of the Smith County if you've got your sentences served. That's all up to the jail. Thankfully, I don't have to keep up with that. I got my hands full.
Okay.
That's no answer to your question. So the answer to your question is, I don't know. Okay?
Okay.
All right. You still awake?
Yes, Your Honor.
I don't want you to doze off on me. All right, let me see. I've almost lost track. Where was I, Mr. Roberson?
Judge, might have to ask Miss Anderson. I think you were going over had he had anything to drink in the Smith County Jail.
Where was I, Miss Anderson? I got off answering all those questions and I lost track of where I was.
I think that's about where we were.
Where were we?
If he had anything to consume or drink in Smith County Jail.
Under the influence.
All right, here we go. I'm with them now. I'll just, you read, write, and understand English, isn't that correct, Mr. Fowler?
Yes, Your Honor.
And you have not consumed any alcohol like whiskey in the last 24 hours in jail, is that correct?
Correct, Your Honor.
You aren't under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system, is that correct?
Yes, Your Honor.
You have never been confined in a mental institution or under psychiatric treatment, is that correct?
I have.
Well, now, when was that?
When I was in high school.
That would be some number of years ago, correct?
Yes, Your Honor.
Are you under any type psychiatric care or taking any type medication for any psychosis or other psychotic condition at this time?
I am, but the nurses, when I talked to the nurse, she said she wouldn't put me on there. I've been asked when I first came down here that I was, and they don't want to put me on there. I've been trying to get on my medication.
You don't need to explain to me what it is. My only question to you is, are you taking the medication prescribed to you in accordance with the prescription?
No.
Okay. Okay. All right. Well, tell me again, don't go into what you're prescribed to take, but who has prescribed you a medication?
My actual doctor out there in the world, her name is Dr. Ho out of Conroe, Texas. She works at Lone Star, and I'm prescribed Adderall and bipolar medication. Okay, well, don't talk about what you're taking anymore, but did you just tell me that you're not taking your medications? No, I'm not taking it because I'm in jail. That's why. But if I was out there in the world, I would be taking it. But since I'm in here, I can't take it. That's what I'm trying to say, Your Honor.
He has not been evaluated by the jail psychiatrist or psychologist, so therefore they haven't prescribed any medication to him while he's in the Smith County Jail. So that was a determination made by a doctor on behalf or psychiatrist on behalf of or psychologist, whatever, on behalf of the jail. Is that correct?
Correct.
Right. Since he has not been evaluated by the jail staff for mental health, they have not prescribed any medication. Okay. All right. I think that answers that one. So let me ask you this question again. Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system other than some type medicine prescribed by a doctor?
No, Your Honor.
Have you ever, and I've asked you this question, but you've told me that you were incarcerated in sometime in a mental institution or under psychiatric treatment. Is that correct?
Yes, Your Honor.
All right. Are you taking medications now?
No, Your Honor.
At one time, were you prescribed medications to take?
Yes, Your Honor.
All right, do you understand everything you're doing in court today?
Yes, Your Honor.
Have you been over everything about the facts of your case and everything you're doing in court today, the allegations in the indictment and all your plea documents with Mr. Roberson, so he has explained them to you as your attorney?
Yes, Your Honor.
Is he competent, Mr. Roberson?
He is, Your Honor.
Any evidence of incompetence, Ms. Anderson?
No, Your Honor.
All right, court, no states counsel sign her consent, approve the waiver of trial by jury. Court approves waiver of trial by jury, all the other waivers signed or signed sworn to by defendant, signed by his attorney. All right, Mr. Fowler, you have gone over the allegations, the charge and the indictment, and you understand the allegations and the charge in the indictment for unauthorized use of a motor vehicle. Is that correct?
Yes, Your Honor.
You understand the full range of sentencing for that offense and all the plea papers I've gone through with you. Is that correct?
Yes, Your Honor.
You have any questions for me about anything?
No, Your Honor.
All right, in cause number 241-1611-21, what is your plea today to the indictment charging you with a state jail felony unauthorized use of a motor vehicle?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, Your Honor.
Has anyone threatened you in any way, promised you anything, or made you plead guilty?
No, Your Honor.
Are you entering your plea of guilty to the indictment for unauthorized use of a motor vehicle today, a state jail felony, freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, Your Honor.
Are you entering your plea of guilty to the indictment today?
Yes, Your Honor.
All right, okay. You know, here's a little, let me add a little to that. Are you entering your plea of guilty to the indictment today because you have any type delusion in your mind?
No, Your Honor.
Are you entering your plea of guilty to the indictment today because you have any unrealistic hope of pardon, parole, or leniency?
No, Your Honor.
All right, the court does receive and accept your plea of guilty to the indictment charging you with unauthorized use of motor vehicle. Go ahead, Ms. Anderson.
We offer states 1, the plea packet with signed waivers and admonishments, states 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
No objection. States Exhibit 1, all the plea documents. States Exhibit 2, the signed and sworn to stipulation of evidence. The States Exhibit 3, discovery compliance, are all admitted into evidence by the court with no objection. The court finding the defendant's waiver of his rights and his execution of all the other plea documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment, charging him with unauthorized use of a motor vehicle as alleged in the indictment, was entered by the defendant to the indictment freely, intelligently, knowingly, and voluntarily. The court, based upon the defendant's plea of guilty, entered to the indictment, which the court has received and accepted, and all of the state's exhibits admitted into evidence on the defendant's plea of guilty to the indictment. The court does find the defendant's guilty of the offense of unauthorized use of a motor vehicle as alleged in the indictment, a state jail felony, and will move to sentencing.
We offer states 4, an electronic copy of the written discovery in this case.
No objection, Your Honor.
States 4, all the written discoveries, such as all the police or sheriff's office reports, those are all admitted into evidence with no objection. Anything else, Mr. Roberson?
No, Your Honor.
Other than the plea agreement. The court in this case then, based upon the defendant's plea of guilty to the offense of unauthorized use of a motor vehicle, a state jail felony, and the evidence presented and admitted into the record by the court, the court does find the defendant guilty of the offense of unauthorized use of a motor vehicle, a state jail felony, as alleged in the indictment, and the court follows the plea agreement, the recommendation of the state agreed to by Mr. Roberson and the defendant, Mr. Fowler, and the court assesses the sentence at 7 months in a state jail facility, assessed with credit for time served. Restitution, if any, is it's supposed to be determined by a post-sentence investigation. Court having received and accepted defendant's plea of guilty to the offense of unauthorized use for motor vehicle state jail felony following the plea agreement assessing the sentence of 7 months in the state jail facility with credit for time served, restitution to be determined, sentence is formally pronounced. Be the order of the court, the defendant will remain in the Smith County Jail until he serves the 7-month sentence with credit for time served, which is all the court can do, assess the sentence at 7 months in a state jail facility with credit for time served in the Smith County Jail. Then it'll be up to the Smith County Sheriff's Office to determine whether or not the defendant will be transported to a state jail facility to serve a remainder of the 7-month sentence with credit for time served in the Smith County Jail, or whether he'll be booked straight out of the Smith County Jail. I don't know the answer to that. You're waiving giving up your right to appeal, waiving giving up your right to file a motion for new trial. Is that correct, Mr. Fowler?
Yeah, Your Honor. Yes,
And
Your Honor.
you're also satisfied with the legal representation provided by your court-appointed attorney, Mr. Clifton Roberson. Is that correct?
Yes, Your Honor.
Anything else, Mr. Roberson?
No, Your Honor.
Anything else, Ms. Anderson?
No, sir.
We are in recess. Thank y'all.
Hey, Charles, can you tell him we need Mr. Gatlin?
Gatlin.
Yeah.
Wow. All right, we're on the record in cause number 241-1443-21 State versus Jerry Gatlin, present before the court by Zoom. With his attorney, Mr. Roberson, present by Zoom. Ms. Anderson, state's attorney, is present by Zoom. 241-1443-21 is on the possession of controlled substance more than a gram, less than 4 grams, methamphetamine, 3rd-degree felony. Cause number 241-1444-21, indictment charging tampering or fabricating physical evidence with intent to impair. That's a 3rd-degree felony as alleged in the indictment. Did I get Mr. Gatlin? Just to be sure, did I get Mr. Gatlin sworn in yet, or did I get off on the indictments?
You need to swear him in, Your Honor.
Raise your right hand, Mr. Gatlin. You solemnly swear your testimony in these cases will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Mr. Gatlin, the first indictment, 1444, actually it's the second one, but it's up on the screen, that 1444-21 charges tampering or fabricating physical evidence with intent to impair. Do you understand the allegations in that indictment?
Yes, sir.
The indictment over in 241-1443-21 charges another 3rd-degree felony offense for possession of a controlled substance more than 1 gram, less than 4 grams. Do you understand the allegations and the charge in that indictment?
Yes, sir.
I've got a set of plea documents in each one of these cases. The plea documents are basically the same. I'm going to identify each plea document. Let's just start with the first one. I'm going to identify the plea documents one time, reference the fact that there are obviously two cases. So we got the same set of plea documents that just vary on the allegations in the indictment next to each case. All these plea documents in both cases, Mr. Gatlin, are signed down there on the right side. I mean, it's signed Jerry Gatlin. I can easily read it, which is nice. But I have to ask you, is that your signature?
Yes, sir.
That's on all the plea documents. Some of these plea documents, did I get him sworn, Ms. Anderson?
Yes, sir.
Some of these plea documents are not, in both cases, are not only signed, they're sworn to by you. When you signed and sworn on all these plea documents in both cases, did you go over all the plea documents with Mr. Roberson, your attorney? So
Yes, sir.
explained them to you. Okay, so you do understand all the plea documents.
Yes, sir.
Here's what we've got in both cases. Both cases, indictments charge third-degree felonies, not less than 2 no more than 10 years in TDC, fine of up to $10,000. In each case, you have a recommendation, a plea agreement from the state that if you do plead guilty to the indictment in each cause number, court's going to follow the plea agreement, assess your sentence at 5 years in the Texas Department of Corrections Institutional Division, with both sentences being done in the same hearing. Then the 5-year sentence assessed in 241-1443-21 would run at the same time as the 5-year sentence assessed in 241-1443-21. And both sentences, they would run concurrent, and also be assessed with credit for time served and you have in the Smith County Jail. Do you understand that?
Yes, sir.
I'm going to go through and I'm going to identify each one of these plea documents one time because you have the same plea documents. They just vary as to the allegations in the indictment. One's going to be a set of plea papers for possession of controlled substance, more than a gram, less than 4 grams, a third-degree felony, tampering or fabricating physical evidence with intent to impair. Same sentencing range, 2 to 10, fine of up to $10,000. So you do understand the allegations and the charge in both indictments.
Yes, sir.
And here I've got the same plea documents. They only vary as to the allegations in the indictment. Same recommendation, 5 years in TDC with credit for time served. I'm going to follow it. The 2 5-year sentences will run concurrent or at the present time with credit for time served, which has been figured by Mr. Roberson. And the jail will be the final one to figure it, but normally Mr. Roberson's right. He's got on here June 17, 2021 to the present. So on the 5-year sentences, you'll be sentenced to at TDC to serve concurrently at the same time. You'll get credit for that time. Now, I'll tell you, the TDC, well, they do their own computations, but according to Mr. Roberson, he's normally right. And here's what I can do, and I'll do, Mr. Gatton. I just assess your time. I assess you credit on your time served. And then the number of days is figured by the jail and TDC. You with me on all that?
Yes, sir.
All right, I've got your plea agreements. They're the same in both cases. 5 years in TDC, credit for time served, ordered to run concurrent, same time. Obviously, your possession of controlled substance, you'll be ordered to pay a $180 lab fee to the Department of Public Safety for the analysis of the controlled substance on the possession of controlled substance. The other indictment charging tampering, fabricating physical evidence with intent to impair. You got any restitution there, Ms. Anderson? Any restitution? I'm sorry.
I'm sorry, Your Honor. No.
Okay, thank you. So your plea agreements, Mr. Gatlin, in each case, 5 years to do with credit for time served. That's what I'm going to assess. Both 5-year sentences will run at the current at the same time with credit for time served. You signed acknowledgement of admonishments in both cases, gives you the full range of sentencing on the 3rd degree, same in both cases. And then there's a total of 7 admonishments. You and Mr. Roberson signed below the 7th one. So do you understand in both cases? All the 7 admonishments, they're the same on each indictment. Do you understand them?
Yes, sir.
In each case, you signed a waiver of trial by jury, where in each case you waive and give up your right to a jury trial and just tell the court you want to plead guilty and have the court hear your plea of guilty without a jury and follow the plea agreement. Is that correct?
Yes, sir.
You signed and sworn to a waiver of confrontation with witnesses, and that same signed and sworn to waiver contains an agreement to stipulate testimony. The agreement to stipulate testimony is over in the stipulation of evidence, states two, signed, and I did get him sworn to. Is that correct, Ms. Anderson?
Yes, you did, Your Honor.
Okay, so your stipulations of evidence signed and sworn to by you in both cause numbers. You understand those are just basically written judicial confessions under oath by you to the allegations and the charge in each indictment.
Yes, sir.
And you did sign and swear to each one of those stipulations of evidence along with all the other plea documents freely, intelligently, knowingly, and voluntarily in each case. Is that correct?
Yes, sir.
You've agreed to stipulate testimony in both cases. Each case, you've waived your right of appeal. You've waived your right to file a motion for new trial. You understand that?
Yes, sir.
In both cases, we've already waived the pre-sentence for you in both cases. In each case, there'll be a trial court certification. It's up on the screen. It's the same. You can see where each of their court certifications will be checked to show each one of these cases is a plea bargain case. I'm going to follow the plea bargain in each case, so you have no right of appeal. In addition, you have waived, given up your right of appeal in each case. Do you understand that, Mr. Gatlin?
Yes, sir, I do.
All right, Mr. Gatlin, understanding all these plea documents, your plea allegations in the indictment in each case, and your plea agreement in each case, which is 5 years in TDC with credit for time served in Smith County Jail. You have any questions for me about anything?
No, sir.
All right, do you read, write, and understand English?
Yes, sir, I do.
Have you consumed any alcohol in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of
No.
those substances in your system?
No,
Have you ever
sir.
been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir, I do.
Have you been over everything about the facts of each case, as we said, and all the offense reports in each case with your attorney, Mr. Roberson?
Yes, sir.
Is it competent, Mr. Roberson?
Yes, Your Honor.
Yes, of incompetence, Ms. Anderson.
No, Your Honor.
The court notes State's counsel signed her consent and approved the waiver of trial by jury. Court approves the waivers of trial by jury in each case, and all the other waivers in each case signed or signed sworn to by the defendant and his attorney. All right, in each case now, you have gone over all the allegations, the charge in each indictment, Mr. Gatlin, and all your plea documents and your plea agreement with your attorney, Mr. Roberson. Is that correct?
Yes, sir.
You do understand the full range of sentencing, all your plea documents and your plea agreement in each case. Is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
In cause number 241-1443-21, what is your plea today to the indictment in that case, charging you with the offense of possession of a controlled substance, a third-degree felony?
Guilty.
In cause number 241-1444-21, what is your plea today to the indictment in that cause number, charging you with tampering or fabricating physical evidence with intent to impair, a third-degree felony?
Guilty.
Are you entering your pleas of guilty to the indictments in each cause number today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No, sir.
Are you entering your pleas of guilty to the indictments freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment in each case?
Yes, sir.
Are you entering your plea of guilty to the indictment in either case because you have any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, sir.
Court does receive and accept your plea of guilty to the indictment in both cases, Mr. Gatlin. What do you have, Ms. Anderson?
In each cause number, we'd offer states 1, the plea packet with signed waivers and admonishments, states 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
In both cause numbers, the court admits without objection, states as Exhibit 1, all the documents signed or sworn to by the defendant, signed by the state's attorney, all under states 1. States two, the signed and sworn to stipulation of evidence, signed and sworn to by the defendant, signed by his attorney, the written judicial confession to the offense charged in each indictment. States two, admitted into evidence in each cause number. States three, that's the discovery compliance proved by the court. Discovery compliance. States three, that is admitted into evidence with no objection. The court having admitted into evidence in each cause number, states exhibits 1, 2, and 3, the court does find the defendant's waiver of his rights and his execution of all the other documents in each cause number were done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's pleas of guilty to the indictments in each cause number were entered by the defendant to the indictments in each cause number freely, intelligently, knowingly, and voluntarily. Therefore, the court, based upon the defendant's pleas of guilty to the indictment, admitted into evidence to the indictment and the evidence admitted by the court, the stipulation of evidence, as well as the other documents admitted into evidence in each of the cause numbers by the court. Any legal reason to bar formal sentencing?
No legal reason, Your Honor.
Finding none, the court does formally pronounce sentence in each cause. Now the court does find the defendant guilty of the offense alleged in the indictment. Follows the possession of controlled substances alleged in each indictment, a third-degree felony. The court finds the defendant guilty of the offense alleged in the indictment. Each cause number follows the plea agreements, recommendation of state, and the session of the sentence at 5 years in the Texas Department of Corrections Institutional Division assessed in each cause number. The 5-year sentence is assessed by the court following the plea agreements, and each cause number are ordered to run concurrent or at the same time with credit for time served. Sentence is formally pronounced. Waivers of appeal are accepted, giving up the defendant's right to appeal. Waivers of right to file motion for new trial. Those are accepted by the court, waiving, giving up the defendant's rights to file motions for new trial. Sentence is formally pronounced in both cases at 5 years in TDC. Order to run concurrent or at the same time with credit for time served. Waivers of appeal, waivers of right to file motion for new trials accepted by the court. Mr. Gatlin, are you satisfied with the legal representation of your court-appointed attorney, Mr. Robertson?
Yes, sir.
You'll be continued in the custody of the sheriff till you can be transported to a Texas Department of Corrections unit to serve the 5-year sentence assessed by the court on the indictment in each cause number. Each 5-year sentence being ordered to run concurrent or at the same time with the other 5-year sentence with credit for time served. Anything else, Ms. Anderson?
Just a copy of states 4 for sentencing purposes, which is an electronic copy of the written discovery in this case.
No objection, Your Honor.
With no objection, states for all the electronic discovery that is admitted into evidence at each cause number without objection. Anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Robertson?
No, Your Honor.
Defendant's order continue the custody of the sheriff till he can be transported to the Texas Department of Corrections Institutional Division, serve the 5-year sentence assessed by the court with credit for time served on each indictment and each 5-year sentence assessed by the court following the plea agreements in each cause number are ordered to run concurrent or at the same time with credit for time served. We're in recess on both cases. Defendants continue in custody until they can be transported to TDC to serve the remainder of the sentence. Credits granted on both sentences. I couldn't hear you. Yeah, really did. Clifton, Ms. Anderson, I'm gonna take about just a quick 5-minute recess.
Yes, Your Honor. All right, Tandy, the judge gonna be within a few minutes. Had to take a break. Give about 2 minutes, okay?
All right. You're next. Are you serious? Yes.
Judge, I believe we are ready now.
Sorry, Your Honor, my
Oh.
5-minute break took a little longer than yours.
Do what?
My 5 minutes took a little longer than yours. I'm sorry.
I wasn't gonna bring that up. That's maybe dangerous territory. All right, we're on the record. I'm sorry. What? Here we go. We're on the record in cause number 241-1175-21. State versus Tandy Cotton, present before the court by Zoom, with her attorney, Mr. Roberson. State's counsel, Ms. Anderson, is present. Court's probation officer is present. This is on a motion to the state to withdraw its motion to adjudicate and amend the terms of community supervision. It's up on the screen. Ms. Cotton, raise your right hand. Let me get you sworn in if I haven't lost track. You solemnly swear your testimony will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Ms. Cotton, that motion of the state to withdraw its motion to adjudicate and amend the terms of community supervision, do you understand that motion? In other words, have you been over it with Mr. Roberts?
Yeah, for the most part.
What's going to take place here? I'm going to grant the state's, of course, if the state had proceeded into court on that motion to adjudicate and proven to the court, the judge, that you had violated any terms and conditions of your deferred adjudicated probation, the court would have granted the state's motion to adjudicate. Just a big legal word, meaning the court would have gone back and found you guilty of the offense of possession of a controlled substance alleged in the indictment as a third-degree felony. That would mean after that was done, the court, because you violated deferred and you'd been adjudicated and found guilty of third-degree felony, and you were on deferred until you violated it and you were adjudicated, the court could assess your sentence up to 10 years, the maximum in TDC, and a fine of up to $10,000. So you know what you were looking at? You understand the consequences?
Yes, sir.
The reason I'm running this by you is that I won't do it again.
Yes, sir.
So I'm gonna grant the motion of the state to withdraw its motion to adjudicate, and I'm gonna amend the terms of your community supervision. That's on the screen. When you see that order, it'll tell you I'm granting the state's motion to withdraw its motion to adjudicate. And then that is granted. And then it says, and the conditions of community supervision probation heretofore granted to you in this case, being all things continued in full force and effect. So that means when you step out of jail into the probation department, all your former terms and conditions of your deferred adjudicated probation, some of which you violated, are in place and continued. Do you understand that?
Yes, sir.
These are the new ones. Number 54, you can read it right there in front of you. Number 54, you're assigned to a level 2 intensive supervision for a term of 2 years. During this term, you're to report in person each week as directed by your supervision officer. Do you understand that, number 54?
Yes, sir.
Here's 55. You're ordered to submit to a substance abuse felony punishment facility as ordered by the attached special condition of community supervision. Supervision fees are waived while you're in custody, that would be in jail, awaiting safe-P placement, and then while you participate in the safe-P inpatient program. Payment of all other court-ordered fees will begin upon release from the safe-P inpatient program. Do you understand that?
Yes, sir.
57, you're ordered as a condition to remain in the Smith County Jail until you're transported into the Substance Abuse Felony Punishment Facility Program. Do you understand that?
Mhm.
They will transport you when there is an opening in the facility. So I don't know when that'll be, but the jail will keep up with it. And when there's an opening, and the probation department will too, when there's an opening in a substance abuse felony punishment facility program, they'll transfer you to it. You understand that?
Yes, sir.
Under 60, you're to attend and successfully complete all aftercare programs for alcohol and drug treatment as directed by your supervision officer. So when you come out of that safe, of course, if you don't successfully complete all the programs in the safe-P punishment facility program, that'll violate your probation. They'll send you back to jail. If you're successful in completing the substance abuse felony punishment facility program, then you're going to have aftercare to deal with your problems in terms of drugs or alcohol. Looks like you've got an alcohol program, an alcohol problem. So your 60th condition says when you come out of that facility, hopefully you will successfully, you're ordered to attend and successfully complete all your aftercare programs for alcohol and drug treatment as directed by your supervision officer. Do you understand that?
Yes, sir.
So the court is granting the motion of the state to withdraw its motion to adjudicate, which if they'd gone forward on it and proved violations, you I'd have gone back, found you guilty, and could have given you the maximum. But I'm granting their motion to withdraw their motion to adjudicate and amend the terms of community supervision. So all your former terms and conditions of your deferred adjudicated probation, including the ones you violated, they're in full force and effect now and continue. Do you understand that?
Yes, sir.
Here's the new ones. 54, you're assigned to a level 2 intensive supervision for a term of 2 years. And during this term, you're ordered to report each week as directed by your supervision officer. Do you understand that?
Yes, sir.
This is the one we were talking about. 55, submit to a substance abuse felony punishment facility as ordered by the attached special condition of community supervision. Supervision fees are waived while you're in custody in jail, awaiting Safe P placement, and while participating in the Safe P inpatient program. Payment of all other court-ordered fees will begin upon release from the Safe P inpatient program. Do you understand that?
Yes, sir.
Successfully completing this substance abuse felony punishment facility program as ordered by the court under this special condition is a term and condition of your probation. Do you understand that? You understand that?
Yes, sir.
If you go to the Safe P program, which is where you're going, because you'll be in jail until you transport to the Safe P program. If you bust out of the Safe P program, if you don't successfully complete the Safe P program, you'll be sent back to jail. And then the state, Ms. Anderson, will use that to file to adjudicate your probation and send you to do a term of confinement like in a state jail. You with me on that?
Yes, sir.
So it's a term and condition of your deferred probation. So you've got to complete it or the state will use it as a violation to adjudicate or revoke your probation. You got any questions for me?
And how long is that term on the Safe P?
That would, well, you're on a level 2 intensive supervision for a term of 2 years. My experience is it sort of depends on how you do, on how long you last.
Yes, sir.
I would say, what would be your estimate, Ms. Anderson?
I probably would defer to what Ms. Morales would say, but I believe Safe P is standardly anywhere between 9 and 12 months. Is that fair, Ms. Morales?
Yes, that is correct.
From nine to, go ahead. I'm sorry.
I think we've got an echo with Ms. Morales there. She muted. Anywhere from 9 to 12 months. It just depends on how quickly you're able to complete and satisfy all the requirements.
9 to 12 months. All right. Court's granting the motion of the state to withdraw the motion to adjudicate and amend the terms of community supervision signed and entered by the court this 10th day of November 2021. Do you have any questions about any of this, Ms. Cotton?
As of right now, if I were to take the other route, what would my offer be for time served and TDC time?
It beats me. That
I
would be,
told her that the state had not given her an offer. The offer was to Safe P because everybody thought that she needed some help for drug abuse. This was the violation was for, Your Honor. So there has not been any kind of plea bargain on any kind of time, Your Honor.
so what Mr. Ropes is telling you is no one can answer that question right now.
Okay.
Because the state, your attorney, Mr. Robertson and Ms. Anderson, they haven't engaged in plea negotiations to determine what agreed term would be recommended for you by the state of confinement, because everyone involved obviously feels like it's best for you to go to the Safe P program because frankly, based on my few years of experience, close to 40 now, if you just go back, if you don't complete, if you go to TDC, Mr. Robertson can negotiate that for you. But if you just go to TDC and do whatever time and eventually parole out of TDC and don't get the treatment you need, which you will get at Safe P, you'll be back on the dope and back in jail.
Yes, sir.
Your best bet of beating this habit is to go through the Safe P program and successfully complete it, because they have a high success rate.
Okay.
Okay, so I hope that answers your question about all I can tell you.
Yeah.
No, be the order of court, then you're content to custody of the sheriff until you can be transported to a Safe P facility to successfully complete the Safe P program as a term and condition of your probation. Anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Roberson?
No, Your Honor.
Well, you satisfied Miss Kristen Lee Slack with the legal representation of your court-appointed attorney, Mr. Roberson? Can you hear? Oh, yeah, I think she could hear. Can you hear me? Are you satisfied with Mr. Roberson's legal representation? I think we got her cut off.
She just
Let
muted.
him,
Yeah, I'm good.
Can you hear me?
Yes, sir.
Are you satisfied with Mr. Clifton Roberson's, your court-appointed attorney, his legal representation?
Yes, sir.
All right, we're in recess. Defense continuing custody, she can be transported to an opening in the safe P facility that successfully completed as a term of her probation. We're in recess.
Tandy, let them know we need Kristen Slack, please.
Yes, ma'am.
I'm gonna sit right here, but I gotta handle one matter. It'll take me about a minute. All right, back on the record, excuse me, back on the record in cause number 2410933-21, State versus Kristen Lee Slack. Present before the court with her attorney, Mr. Roberson. Ms. Anderson is present for the state. Probation officer is present. This is a motion of the state to withdraw its motion to adjudicate and amend the terms of community supervision. Ms. Anderson?
Yes, sir.
Go ahead on your motion.
Your Honor, this is similar to the last motion. We're asking to withdraw ours and allow Ms. Lee Slack to remain on probation and go to safety.
Ms. Kristen Lee Slack, can you hear me?
Yes, sir.
Let me raise your right hand. Let me get you sworn in, be sure I've got this on the record. Do you solemnly swear your testimony will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Have you gone over the motion of the state to withdraw its motion to adjudicate and amend the terms of your probation with your attorney, Mr. Roberson?
Yes, sir.
You understand, of course, had the state proceeded on its motion to adjudicate that triggered a no bond warrant landing you in jail. If they'd gone forward on the motion to adjudicate and prove violations to the court would have granted the state's motion to adjudicate, gone back and found you guilty of the offense charged in the indictment, and then because you were on deferred, the court could have sentenced you up to the maximum for that offense. Do you understand that?
Yes, sir.
Here's the order that I'm signing. It's up on the screen. You can see it. It's therefore ordered, adjudged, and decreed by the court that the motion of the state to withdraw its motion to adjudicate you, as stated above, being the same is hereby granted. And the conditions of community supervision heretofore granted in this cause being all things continued. Right there, that means that all of your former and present conditions of your deferred adjudicated probation, the ones you went out on, all of them are being continued in full force and effect. Do you understand that?
Yes, sir.
Here are the new ones. 54, you're assigned to a level 2 intensive supervision for a term of 2 years. And during this term, you're ordered to report each week as directed by your supervision officer. Do you understand that?
Yes, sir.
55, you're ordered to submit to a substance abuse felony punishment facility as ordered by the attached special condition of community supervision. Supervision fees are waived while in custody awaiting safety placement and while participating in the safety inpatient program. Payment of all other court-ordered fees will begin upon release from the safety inpatient program. Do you understand those conditions?
Yes, sir. I have one question about those.
Go ahead.
On the Safe P, will they be able to treat me with my mental health needs as well?
When you get down to Safe P, they'll do an examination. You'll talk to them about, you'll need to, of course, they'll have records that the jail has, but you need to be sure, and they'll do an interview with you and they'll be asking you questions, and you'll see, obviously, you need to fully explain to them and tell them what that condition is.
Yes, sir.
Okay. Now they primarily individuals going down there are going to Safe P program for treatment of an alcohol program. So right off is for us whether or not they would be able to treat you for your mental health condition, not knowing what it is. I don't want to say what it is on the Zoom, but I'll ask Ms. Anderson to check that, and she can let Mr. Roberson know, and he'll let you know. I don't recall right off whether or not they do that. My guess is they would if they have all the records of yours on that mental health condition.
It's my understanding, and Ms. Morales can correct me if I'm wrong, it's my understanding they will do a mental health assessment in conjunction with the substance abuse treatment, and they will address those issues with counseling and things while you're there.
Well, that would be correct then. I didn't recall from the last one I'd had on that, but Ms. Anderson, as usual, has a pretty good recall. So I think you can rely on that, and they'll be able to treat you for your mental health condition while you're down there, Ms. Slack.
Yes, sir.
All right, so the order of the court is, I'll just read it to you so that you know the state is withdrawing its motion to adjudicate. As you know, if they'd gone forward on it, proven violations of your deferred, the court would have gone back, found you guilty, and then I could assess your sentence up to the maximum. However, their motion to withdraw their motion to adjudicate is granted, and the conditions of your community supervision probation heretofore granted are continued in all full force and effect. Do you understand that?
Yes, sir.
With amended new conditions as follows. 54, you're assigned to a level 2 intensive supervision for a term of 2 years, and during this term, you're ordered to report each week as directed by your supervision officer. Do you understand that?
Yes, sir.
55, you're ordered to submit to a substance abuse felony punishment facility as ordered by the attached special condition of community supervision. Do you understand that?
Yes, sir.
Supervision fees are waived while you're in custody, awaiting Safe P placement and while participating in the Safe P inpatient program. Do you understand that?
Yes, sir.
Payment of all other court-ordered fees will begin upon release from the Safe P inpatient program. Do you understand that?
Yes, sir.
You're ordered as a condition of going to the program, and one of those conditions is you're ordered to remain in the Smith County Jail until you're transported to the Substance Abuse Felony Punishment Facility Program. Do you understand that?
Yes, sir.
60 is a condition that you're ordered to attend and successfully complete all aftercare programs for alcohol drug treatment as directed by your supervision officer. Do you understand that?
Yes, sir.
Do you have any questions about any of these conditions?
How long is this Safe P program?
Go
It's
ahead.
approximately 9 to 12 months.
9 to 12 months. Of course, it's designed and it will work if you apply yourself. If you work and apply yourself, my experience over quite a few number of years is it will be a successful program. If you bear down and you follow the conditions, then you have a really high likelihood of beating this substance abuse problem. And the reason I'm ordering you to Safe P is the same reason Ms. Anderson's recommending it and Mr. Robeson's agreed to it. We know if you don't get this intensive Safe P program treatment, it's just a matter of time before you're back in jail and then down at the Texas Department of Corrections doing time because of a drug problem. That's what this is all about, is getting you off the illegal substances. But I don't know. I think Ms. Anderson just gave you an estimate about how long it lasts.
Yes, sir.
Do you have any other questions?
No, sir.
All right. Are you satisfied with the legal representation of your court-appointed attorney, Mr. Roberson?
Yes, sir.
Ms. Anderson, Ms. Anderson, do you have anything else you need me to explain?
No, sir.
Do you have anything else, Mr. Roberson?
No, Your Honor.
All right, I've signed the order granting the motion of the state to withdraw its motion to adjudicate and amend the terms of community supervision as set out in the order that I've gone over. Defendants continue the custody of the sheriff till she can be transferred to the Safe P facility. What's
Oh, our next one.
Let them know that we need Vic Gardner, please.
All right, counsel, we're on the record in cause number 2410158-21 State versus Vic Garner on indictment charge of possession of a controlled substance. Here's he's before the court by Zoom with his attorney, Mr. Roberson, by Zoom. Ms. Anderson, state's attorney, is present by Zoom. Mr. Roberson, you want to waive the reading and formal presentation of the indictment and all the other formalities?
Judge, waive formal reading of the indictment. His name is correctly set forth in the indictment. Knows the range of punishment, what he's charged with. Gonna change his plea from not guilty to guilty, Your Honor.
Okay, raise your right hand, Mr. Garner. Just raise your right hand. Do you solemnly swear the testimony you'll give in the cause now on trial will be the truth, the whole truth, and nothing but the truth, and that all these documents would show that sworn by you and sworn to by you are being sworn to by you now under oath, freely, intelligently, knowingly, and voluntarily?
Yes,
All right, Mr. Garner, you understand all the allegations and the charges in the indictment for possession of a controlled substance, state jail felony?
yes, sir.
You understand the full range of sentencing is set out in your admonishments is not less than 180 days and more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. You understand that?
Yes,
That's the full range. You have a plea agreement with the state where Ms. Anderson is recommending if you do plead guilty to this indictment, she's recommending your sentence at 12 months in a state jail facility. That would be assessed with credit for time served in the Smith County Jail. Pursuant to Penal Code Order 1245, the court will take into consideration an offense for false drug test device under DA number 20-03867. That misdemeanor will then be dismissed in this plea. Is that the plea agreement, Mr. Roberson?
Yes, Your Honor.
Is that your plea agreement, Mr. Garner?
yes, Your Honor.
Is that it, Ms. Anderson?
It is, Your Honor.
All right, now, all these documents, the easiest one to look at is the one on the, I mean, I can easily read your signature, signed Bick Garner, but I have to ask you, is that your signature?
Yes, sir.
All right, it's on all the plea documents, so whether you sign the plea document or signed and sworn to, and now it's the ones that are sworn to, you sworn to them. Do you understand, have you been over all these plea documents with Mr. Roberson so you understand your plea documents?
Yes, Your Honor.
What I'm going to identify for the record, if you plead guilty to the state jail felony possession of a controlled substance, I'm going to follow your plea agreement state's recommendation to assess your sentence at 12 months in the state jail with credit. Do you understand that?
Yes, Your Honor.
I've been over the 1245 to go in as part of a sentence. There's an acknowledgement of admonishments, explanations, 7 of them. You and Mr. Roberson signed below the 7th one. Do you understand all 7 admonishments?
Yes, Your Honor.
You're waiving giving up your right to a jury trial. Do you understand that?
Yes, Your Honor.
And you're waiving confrontation with witnesses and agreeing to stipulate testimony. Do you understand that?
Yes, Your Honor.
You understand the stipulation of evidence is the stipulation of evidence states to the next document signed and sworn to by you and signed by Mr. Roberson, signed and sworn to by you, signed by your attorney. That stipulation of evidence is a full written judicial confession under oath by you to the allegations of the charge in the indictment. Do you understand that?
Yes, Your Honor.
You've signed, along with your attorney, signed off on by the state, you signed an agreement to stipulate testimony, which is actually the stipulation of evidence. You signed a waiver giving up your right to file a motion to new trial. You signed a waiver giving up your right to appeal. Do you understand those waivers and those rights you're waiving and giving up?
Yes, Your Honor.
When you're requesting, of course, waiver of the pre-sentence, that's been done. There's a trial court certification of your rights to appeal that already is checked, which is correct, shows a plea bargain case, and you have no right of appeal because I'm going to follow the plea bargain. And you've also waived your right to appeal. Do you understand that certification?
Yes, Your Honor.
Then you've filed an advice you've received on your right to appeal with the court, which gives up your right to appeal. Now, understanding all your plea documents, understanding the allegations and the charge for this state jail felony offense, possession of a controlled substance less than a gram net, and the plea bargain on your time to do, where the state recommends 12 months in the state jail facility with credit for time served, you still wish to go forward on your plea of guilty without a jury? You still wish to go forward and plead guilty?
Yes, Your Honor.
All right, do you read, write, and understand English?
Yes, Your Honor.
Have you consumed, drank any alcohol in the last 24 hours?
No, Your Honor.
Are you under the influence today of any type drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, Your Honor.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, Your Honor.
You understand everything you're doing in court today?
Yes, Your Honor.
Have you been over everything about the facts of your case and everything you're doing in court today with your attorney, Mr. Roberson?
Yes, Your Honor.
You competent, Mr. Roberson?
Yes, Your Honor.
Any evidence of incompetence, Ms. Anderson?
No, sir.
Court no State's counsel sign her consent approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed by the defendant, signed or sworn to by the defendant, signed by his attorney. All right, now you understand, Mr. Garner, all the allegations, the charge in the indictment against you, your full range of sentencing and all your plea documents. Is that correct?
Yes, Your Honor.
You have any questions for me about anything?
Will I be receiving time served?
Yes. When I assess this sentence at 12 months following the plea agreement, that sentence of 12 months, you'll hear me pronounce it 12 months with credit for time served.
Thank you, sir.
All right. Then understanding all your plea documents and your plea agreement in cause number 2410158-21, what is your plea today to the indictment charging you with possession of a controlled substance less than a gram, a state jail felony? Is your like plea guilty or not guilty?
Guilty, Your Honor.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, Your Honor.
Has anyone threatened you in any way, promised you anything, or made you plead guilty?
No, Your Honor.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, Your Honor.
Are you entering your plea of guilty to the indictment today because you have any type of delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, Your Honor.
Court does receive and accept your plea of guilty. What do you have, Mr. Roberson? I'm sorry, what do you have, Ms. Anderson? I'm sorry.
We offer states 1, the plea packet with signed waivers and admonishments, states 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
No objection. The court admits into evidence states 1, all the plea documents, states 2, signed, sworn to stipulation of evidence, states 3, discovery compliance. Court having admitted into evidence states exhibits 1, 2, and 3 with no objection. The court does find the defendant's waiver of his rights, execution of all the other documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty to the offense alleged in the indictment. The court does follow the plea agreement, the recommendation of the state, assessing the sentence at 12 months in a state jail facility, assessed with credit for time served, restitution order to DPS for the lab analysis on the controlled substance in the amount of $180. Illegal, reasonable, or formal sentencing.
No legal reason, Your Honor.
Finding none, sentence is formally pronounced. Court does find the defendant guilty of the offense possession of controlled substance less than a gram. State jail felony is alleged in the indictment. Assesses the sentence at 12 months in a state jail facility. Assessed with credit for time served, restitution order to the DPS lab. 12-month sentence is assessed with credit for time served. Sentence is formally pronounced. Waiver of appeals accepted. Waiver of right to file a motion for new trials accepted. Be the order of the court that Mr. Garner be continued in custody of the sheriff until he be transported to a state jail facility to serve the sentence assessed by the court, the 12-month sentence assessed by the court with credit for time served he has in Smith County Jail at the time he goes to the state jail facility. Anything else, Mr. Roberson?
Judge, he does have some time from Gregg County. I told Tabitha I will get with her because they had a hold on him in Smith County over in Gregg County, and I will get her that time, Your Honor.
Just get with Miss Anderson on it, whatever y'all figure out. Ms. Anderson can let Tabitha know, and it'll go on the judgment for credit for time served. Anything else, Miss Anderson?
We just offer states 4 for sentencing purposes, Your Honor.
Good deal. States 4 is in for sentencing purposes.
Can I say something?
I don't know what, hang on a minute. I don't know what you're going to say. You going to be talking to the court or to your attorney?
Well, to the court, I was diagnosed with stomach cancer by Dr. White back in 20th of October.
Okay. I don't, of course, all I can say about that is, that's not a good situation. I don't have any information on your current condition, but I would suggest you give, if you have any updates on that, be sure Mr. Robertson has them. The main thing there is when you are transported to the facility that you're going to, all your medical records need to go. That diagnosis you just referred to and gave to the court, that diagnosis from that doctor needs to go to the facility with you. And I'm sure Mr. Robertson can see to it that that's included in your packet. And then, of course, obviously they've got the facilities down at the state jails. They'll have facility access facilities. I don't know. I'm not a doctor, so that'd be an understatement, but I'm sure that when you get down there, if your records are with you on that diagnosis of stomach cancer, I think that's what you said, then, you know,
Yes, sir.
they'll have treatment down there for you. Just need to be sure your records from your doctor go with you. If you've got them, they'll go. Are they at the jail?
Dr. White is Smith County doctor.
Okay. Well, then they should have the records. Mr. Robertson, be sure those records are in his pen pack.
And Judge, I will, and also I've been in contact with his attorney over in Gregg County, John Moore. It's a situation, Judge, with the amount of credit that he has, and when they get him to Gregg County, he'll probably have his time served, so that way they can go ahead and let him see a free world doctor, Your Honor.
Okay, Mr. Robertson, so if I'm following you, he's getting credit for his time served here. He's been found guilty, assessed the sentence here. That was agreed on with credit for time served. So he's going from the Smith County Jail over to the Gregg County Jail where Mr. John Moore represents him.
Yes, that is correct, Your Honor.
Okay, they'll get all that figured out. There's nothing further, we're in recess. Defendant's continuing in custody till he can be, sentence has been formally pronounced. Defendant's continuing in custody till he can be transported, based on what Mr. Robertson just said, over to the Gregg County Jail to resolve his cases over there where he's represented by Mr. John Moore. All right, if there's nothing else, counsel, we're in recess on this case.
Thank you, Your Honor.
Mr. Garner, will you let them know we need Miss Lane next?
Ma'am,
We need Miss Lane.
All right, we're on the record in cause number 241-1498-21 State versus Arena Lane, present before the court from Smith County Jail by Zoom. It's on indictment charge of possession of controlled substance less than a gram meth. She's present by Zoom. Her attorney, Mr. Robertson, is present by Zoom. Ms. Anderson, state's attorney, is present by Zoom. Ms. Lane, just raise your right hand. If I have to swear you in. You solemnly swear the testimony you'll give before the court today will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, Ms. Lane, I've got a set of plea papers here. First of all, your indictment's up on the screen. Do you understand all the allegations of the charge in the indictment, which charge you with possession of controlled substance less than a gram of state jail felony?
Yes, sir.
All right, moving on to your plea documents. All these plea documents, when you look at the first one, which will be your agreed punishment recommendation, down the right side, you'll see a signature, appears to be Arena Lane. Is that your signature above where it says defendant?
Yes, sir.
Your signatures on all these plea documents are also signed by Ms. Anderson, representing the state, and your attorney. And you understand I've sworn you to these documents now, and you've sworn that you signed them, and also sworn that your testimony will be the truth, the whole truth, and nothing but the truth? You with me on all that?
Yes, sir.
You have a plea agreement with the state I'm going to follow with Ms. Anderson. If you enter a plea of guilty to the state jail felony, possession of a controlled substance less than a gram, I'm going to follow your plea agreement, assess your sentence at 3 years, deferred adjudicated probation, withhold the finding of guilt, place you on the deferred adjudicated probation. Then you'll be supervised by the Smith County Probation Department, be unannounced drug testing and reporting requirements and about 70 conditions of your deferred adjudicated probation. The probation officer who's on the screen will explain to you what you need to do when you book out. And is that your plea agreement, Ms. Lane?
Yes, sir.
Is that it, Mr. Roberson?
Yes, Your Honor.
Recommendation, Ms. Anderson?
It is, Your Honor.
All right, got an acknowledgement of admonishments. It gives you the full range of sentencing, Ms. Lane, right at the top, not less than 180 days, no more than 2 years in a state jail facility. Fine may be assessed up to $10,000. Going to the second page, there's a total of 7 admonishments. They're right above, last one's the 7th is right above your signature and Mr. Roberson's. Do you understand all 7 admonishments, explanations?
Yes, sir.
You understand you're waiving, giving up your right to trial by jury by document?
Yes, sir.
Which says waiver of your right to trial by jury. You're waiving confrontation with witnesses, agreeing to stipulate testimony. Now, your stipulation of evidence is your stipulation of testimony. It's signed and sworn to by you. Basically, is a written judicial admission under oath by you to all the allegations and the charge in the indictment. Do you understand that?
Yes, sir.
You sign and swear to the stipulation of evidence of your own free will, sign it voluntarily.
Yes, sir.
There's an agreement to stipulate testimony. You and Mr. Robeson have signed a form waiving, giving up your right to appeal, and waiving, giving up your right to file a motion for new trial. Do you understand that?
Yes, sir.
And there's a trial court certification that'll be checked, it'll show, be signed by the court and checked to show this is a plea bargain case and you have no right of appeal, and it'll be checked to show you waived your right to appeal. Now, understanding the allegations, the charge in the indictment for possession of a controlled substance less than a gram, your plea agreement, and all these plea documents, do you still wish to go forward on your plea of guilty without a jury?
Yes, sir.
Did you read, write, and understand English?
Yes, sir.
Have you consumed any alcohol in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have
No.
any of those, you have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything about the facts of your case and everything you're doing in court today with your attorney, Mr. Roberson?
Yes, sir.
Is you confident, Mr. Roberson?
Yes, Your Honor.
Yes, of incompetence, Ms. Anderson.
No, Your Honor.
State's attorney signed her consent, approved a waiver of trial by jury. Court approves a waiver of trial by jury. All the other waivers in the plea documents signed or signed sworn to by the defendant, signed by her attorney. All right, now, Ms. Lane, do you understand all the allegations on the charge in the indictment against you for possession of a controlled substance less than a gram?
Yes, sir.
You understand that's a state jail felony. Your full range of sentencing is not less than 180 days, no more than 2 years in a state jail facility, and a fine may be assessed up to $10,000. You understand that?
Yes, sir.
And you've been over with Mr. Roberson how deferred adjudicated probation works, correct?
Yes, sir.
If you violate any of the terms and conditions of your deferred adjudicated probation, Ms. Anderson, like failing a drug test, Ms. Anderson will file a motion to adjudicate you. That's just a motion alleging violations of your deferred, but it'll trigger a no bond warrant for your arrest. Then once you turn yourself in or you're apprehended, if the state proves to the judge of the court, not to a jury, it's not a jury trial, but you violated any of the terms and conditions, the judge will grant Ms. Anderson's motion to adjudicate, go back and find you guilty. Then the judge can give you the maximum up to 2 years in state jail facility and fine of up to $10,000. You understand that?
Yes, sir.
All right, let me go back and be sure I've got your plea in the record. Do you have any questions for me about anything?
Yes, sir. Is it possible that I leave today, like book out today?
Is it possible?
Or am I gonna leave today?
I have no more earthly idea about that than the man in the moon. That question often comes up. It depends on where the jail is on booking out inmates. You may book out the day before 5 o'clock. If you do, you have to report directly to your supervision probation officer at the probation department. Probably more likely you would book out sometime this evening, but I don't know. If you book out after 5, you have to be in your probation officer's office, obviously at the probation department, by 8 o'clock in the morning. But when you'll actually be booked out, it could be any time from this afternoon till midnight or so. I don't
Yeah.
know. It depends on how many they've got in front of you, and I have no idea.
Yes, sir.
All right, anything else on that, Mr. Rose?
No, Your Honor.
All right. Ms. Anderson, she did enter her plea to the indictment before I got off on all the other, didn't she?
No, sir. We
All
just
right.
talked about, you just asked us about competency.
It calls number 241-1498-21. What did you say about competency, Ms. Anderson?
I said that's where we left off. Right before we took her plea, you'd asked about her competency.
All right, thank you. Glad you keep up with me. Is she competent, Mr. Roberson?
She is, Your Honor.
Any else of incompetence?
Still none, Your Honor.
All right, court. Note, State's counsel signed her consent to approve the waiver of trial by jury and all the plea agreements. Now, having gone over all your plea documents with Mr. Roberson, understanding the allegations in the indictment, other than the question you've asked me, which I couldn't answer, do you have any other questions?
No, sir.
Okay, you understand all the allegations, the charge in the indictment, the full range of sentencing and all your plea documents, is that correct?
Yes, sir.
All right, in cause number 241-1498-21, what is your plea today to the indictment charging you with possession of a controlled substance less than a gram?
June the 15th.
I'm sorry?
What did you ask? I'm sorry.
Well, what is your plea today to the indictment, guilty or not guilty, charging you with possession of a controlled substance less than a gram?
Probation.
No, are you guilty or not guilty?
I'm guilty.
That's the sentence the court is going to follow because that's your plea agreement. But all I'm doing now is asking you whether or not your plea to the indictment is guilty or not guilty.
Oh, guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you in any way, promised you anything, or coerced you, made you plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, sir.
Are you entering your plea of guilty because you have any type of delusion in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, sir.
The court does receive and accept your plea of guilty to the indictment. What do you have, Ms. Anderson?
We offer states 1, the plea packet with signed waivers and admonishments, states 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
With no objection, the court admits into evidence states 1, 2, and 3. All the plea documents, the signed and sworn to stipulation of evidence and discovery compliance, all admitted with no objection. The court, having admitted into evidence, states exhibits 1, 2, and 3. Court finding the defendant's waiver of rights and execution of all the other documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in the case was entered by the defendant to the indictment in the case freely, intelligently, knowingly, and voluntarily. Further, the court does receive and accept the defendant's plea of guilty entered to the indictment, follows the plea agreement, the recommendation of the state, and assess the sentence in the case at 3 years. Deferred, adjudicated probation, no fines assessed, court cost ordered paid. Restitution order DPS amount of $180 is one of the conditions of deferred. Any legal reason for formal sentencing?
No legal reason, Your Honor.
Finding none, the court does formally pronounce the sentence, finds the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment, follows the plea agreement, assesses the sentence at 3 years, deferred, adjudicated probation, no fines assessed, court cost order paid, restitution is ordered, BPS in the amount of $180. Now, There's lanes, to be sure you realize this, on that deferred adjudicated probation, you can be on an office for up to 3 years. If you successfully complete your deferred adjudicated probation, pass all your drug tests, don't violate any of your 70 or so terms and conditions of your deferred adjudicated probation, at the end of your 3-year term, you can file a motion and the court will discharge you from deferred adjudicated probation with no
Yes, sir.
with no final conviction on your record, okay?
Yes, sir.
Well, the deal is now on the other side of the road on deferred, if you fail a drug test, fail to report, show positive for any controlled substance, the state will use that to file a motion to adjudicate your case. And the state will allege those violations if they do take place. A no bond warrant would go out before you for your arrest. You'd then appear before the judge of this court, and if the judge of the court found the allegations true that you had violated any of your deferred adjudicated probation, because you're on deferred, the judge would go back. If you violate any of your terms and conditions like failing drug tests, the judge would go back, find you guilty. Then because you're on deferred, the judge can give you the maximum 2 years in a state jail facility and a fine of up to $10,000. You understand all that?
Yes, sir.
Are you satisfied with your legal representation from your court-appointed attorney, Mr. Roberson?
Yes, sir.
It'll be the order of the court, then you'll continue in the custody of the sheriff of Smith County until you can be booked out. It's a determined condition of your deferred when you do book out. If you book out before 5, you have to go directly to the probation department. If you book out after 5, of course, probation closes at 5. You have to be in the probation department reporting to your probation officer at 8 o'clock the next morning. And those are conditions of your deferred probation. You understand that?
Yes, sir.
Is there anything further my probation officer needs to go over with her?
Go ahead, Diana.
The probation department and the courthouse in general.
Oh, I think her sound is messed up. I think what she was going to tell you was that if you do book out today, the probation department is closed.
Hold on, we're in a mess.
The probation department is closed tomorrow. Tomorrow's a holiday. And so if you do book out today, instead of showing up at 8 o'clock Thursday morning, you would need to show up 8 o'clock Friday morning.
Yes, sir. Yes, ma'am.
Okay, thanks, Ms. Anderson. We're in
I'm sorry, one more thing, Your Honor. Can I just get states 4 in for sentencing purposes, a copy of the written discovery?
Yes.
No objections.
States 4 is admitted into evidence for sentencing purposes with no objection. All right, the defendant's she's continued in custody of Smith County Jail until she's booked out to report immediately to the Smith County Probation Department to start her 3-year deferred adjudicated probation term to meet with our supervision officer. You're going to have about 70 or so terms and conditions of your deferred adjudicated probation, Ms. Lane. So listen real closely as they go over each one of them with you, okay?
Yes, sir.
Thank you. We're in recess.
Let them know we need Amy McKnight.
Hey, Clifton,
Changing the number.
Amy McKnight's paperwork still says 3 years deferred, but she had that meth violation, so I took it back up to 5, remember?
No, it was 3 years deferred with Safe P. We added Safe P.
Okay, that's what it is. She's going to go to Safe P first?
Right.
Okay. I did not remember that part. Thank you.
Was that the one we just did?
No, this is another one, Your Honor.
Okay, I was gonna say I gave it wrong. Okay.
I knew we talked about treatment for her.
Yes, the family's in agreement that she needs treatment.
Okay, so Diana, that's one we're adding that I didn't give you this morning. 3 years with safety. Thank you.
All right, so, we're
We
on.
need Amy McKnight.
Okay.
We're on the record in cause number 24106-57-21. State versus Amy McKnight, under indictment, Georgia State Jail, found in possession of a controlled substance. She's present before the court by Zoom with her attorney, Mr. Robeson, present by Zoom. You want to waive the reading and presentation of the indictment and all the other formalities, Mr. Robeson?
Judge Williams, upon reading of the indictment, her name is correctly set forth in the indictment, knows the range of punishment, what she's charged with, gonna change her plea from not guilty to guilty, Your Honor.
Okay, Ms. McKnight, just raise your right hand. I have to swear you in. Do you solemnly swear the testimony you'll give at the cause now on trial will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Ms. McKnight, first of all, up on the screen will be, first document up will be the indictment. Have you gone over the indictment with Mr. Robeson so you understand the allegations and the charge in the indictment for possession of a controlled substance, meth, in an amount of less than 1 gram?
Yes, sir.
You understand full range of sentencing on that offense is not less than 180 days and more than 2 years in a state jail facility. Fine may be assessed up to $10,000. You understand that?
Yes, sir.
All right, now going up on the screen is going to be your agreed punishment recommendation, your plea agreement. There's a signature on the line above where it says defendant. It's signed Amy McKnight. That's on all the plea documents. Is that going to be your signature?
Where at?
You can't see it yet.
Oh, yeah, I can't see
You
nothing.
can't see it. Neither can I. It's nothing on the screen.
Yeah.
I'm so used to it being up there. I just went ahead and said it was there.
I can barely see as it is.
There's nothing wrong with your eyes. I can't see it either. Okay.
I just had another stroke, so I can barely see. I just had my 5th stroke already.
This isn't set.
No, it's not scanned.
What?
It's not scanned.
Oh.
Because we didn't know if it was going or changed. So she'll just have to remember she went
The
over.
document is not scanned in. That's why none of these documents are on the screen that you can see.
Okay.
That's what my court coordinator just told me. So I'll just ask you, since they're not up on the screen because they haven't been scanned in yet.
Sir.
Do you understand all the allegations and the charge in the indictment, Ms. McKnight, alleged as possession of a controlled substance less than 1 gram?
Yes, sir.
And you understand the full range of sentencing for that offense, not less than 180 days and more than 2 years in a state jail facility. Fine may be assessed at up to $10,000.
Yes, sir.
And I've got a set of plea documents here. The first one's the agreed punishment recommendation. They're all signed Amy McKnight as well as by Mr. Ropes. Is that going to be your signature signed Amy McKnight?
Or
Now you
the
can't say, did you sign all the plea papers?
the plea papers that I signed was for probation for 3 years. Yes,
That's
sir. I
it.
did sign for probation for 3 years. Yes, sir.
That's it.
On the 19th and yes, of
Right.
October. Yes, sir.
That's it. So court's going to follow the state's recommendation that you and Mr. Robeson have agreed to. I'll withhold the finding of guilt, place you on deferred adjudicated probation for a term of 3 years. I'll consider a DA number 21-01435, which that's going to be a misdemeanor. I'm going to take it into consideration under 1245. Ms. Anderson will dismiss it or decline it. Now, written on the plea papers here is safe P. That indicates to the court, I'm going to assess your sentence at 3 years deferred adjudicated probation following your agreement and your attorney's agreement with Ms. Anderson. But the first condition of your deferred adjudicated probation is that when you'll be booked out of jail at some point and then transported directly to the Safe P program. If that's the way I take this, is that correct, Ms. Anderson?
It is, Your Honor. Well, I don't know that she books out of jail. I think she stays in jail until a bed becomes available.
That's my understanding.
No, that's when I said when she books out of jail, it's better said like you said, she won't be booked out until there's bed available.
Correct. She
What
waits.
you'll stay in jail, Ms. McKnight, under the court order and the judgment of the court. As soon as there is an available bed in the Safe P facility, you'll be transported to the Safe P facility. It's a lockdown facility for drug abuse treatment and addiction and rehabilitation. And you have to successfully complete that program as a term and condition of your deferred adjudicated probation. Are you with me on all that?
Yes, sir.
And I have no idea how long it'll be between today and when you're transported to the Safe P program. It all depends on when they have openings come up. All right, beyond the plea agreement, is that the plea agreement, Mr. Roberson?
That's correct, Your Honor.
3 years deferred, first condition, you'll stay in jail till you're transferred to the Safe P program, and you have to successfully complete the Safe P program as a term and condition of your deferred adjudicated probation. The other documents I've got are acknowledgement of admonishments. Oh, goodness. Hang on just a minute. Hello? Okay.
Hey, Tabitha, can you hear me?
Yes, ma'am.
Did I remember to, or Clifton probably did. Did Clifton and I remember to 1245, the PDD case on this?
There was a DA number on there.
Okay, it's for PDD.
Okay,
But
I'll check it as soon as I get the
I
paperwork back.
appreciate it. Thanks.
Will I get time served for this or no?
Ma'am, you going to Safe P, and once you get out of Safe P, you'll be on probation.
I know, but what I'm saying is, will this go, all my time go, my back time go towards my probation or anything? Or no?
No, your probation will start until you're released from Safe P.
So go to CP and then probation for 3 years? Or is
Yes,
this gonna be part of my probation?
it's part of your probation, yes.
So CP for, I think 9 months. So 6 months at CP and then 3 months at a halfway house. Correct?
Depends on how you do the program. Yes, it can be from 9 months to a year.
Well, it'll be a life-changing experience. It's something I need.
Do they have LaQuinn out there with you, Miss Matt Knight? Is LaQuinn Williams sitting out there too?
LaQuinn Williams? Yes, sir.
Okay, thanks.
You're welcome. She's the last one.
Yeah, maybe for you, but now for me.
Huh?
Oh, I got about 3 more.
Mm.
I still show like 8 more.
You probably had 8 more. I got 3 more.
No, I mean, with you, hold on.
Are you sure?
Well,
We got LaQuinn, Angela Bircher, and Whitney Underwood.
okay, so we're not doing Victoria Warren.
No, we have to reset her.
Oh, I didn't know that.
Yes, you want to look at her video.
Oh, still?
Yeah,
Okay. Amy McKnight, we're doing right now.
yes,
Just her.
For Quinn, we're gonna do that revo.
yeah.
Oh, Misha Holiday.
She lives in Oklahoma. I gotta get in touch with her. That's been reset.
Okay, I didn't know that. Dominic Davis.
He wants a trial. I told him about the 2 years. I told him in a year credit. He said he still wants a trial.
Okay. So we just need to get him reset for an announcement.
Yes, yes.
You're unmuted.
So there's no other offers but Safe P.
It won't go to any other judge's computer.
Oh, James DeMatty.
He wants to look at the Walmart videotape reset.
So he got reset too? I'm
Yeah.
sorry, I didn't know that either.
All right. Trying to get a blood draw warrant signed, so for a trooper, so he's gonna be coming, I think, by here. And so I may need to loop back. I got off on that, forgot where I was.
Judge, I think you were getting ready to go over the paperwork with her, admonish her about can she read and write and things of that nature.
All right, Ms. McKnight, let me just ask you this.
Yes, sir.
You do understand all these plea documents you signed or sworn to, correct?
Yes, sir. For the probation. Yes, sir.
3 years deferred adjudicated probation. That's
Yes.
what I'm gonna assess.
Yes,
believe
sir.
I was telling you when I got the call on the blood draw on the wreck that it'll be 3 years deferred adjudicated probation. The first term will be safe pay, and you'll be continued in the custody of the sheriff in jail until there's an opening in the safe pay program. Then you'll be transferred to the safe pay program, which you have to successfully complete as a term and condition of your deferred adjudicated probation. You understand that?
Yeah, and you don't know how long that's going to be.
I sure don't. Because one, I don't know where they are on openings at the safety program. I don't know, Mr. Robertson may have checked it. I don't know. I don't have any idea.
And Judge, she was talking about the waiting period. I think the waiting period is about 2 weeks, Your Honor.
That's Mr. Robertson's best estimate. Of course, you can figure this. Individuals are going to safe pay from jails all over the state. So I don't know that, someone would probably have to Mr. Robertson may have checked it, probably have to call safe pay, or the jail would have to call them, which I don't think they usually do. I don't think anybody knows without calling safe pay to find out, like, if they have an opening now. If they don't have one now, they may know when somebody's going to finish up. I just don't know.
And just probation department would do that. They already have 2 more that's they're looking for bed space, and they will look bed space for her too, and they will let them know how long it takes to get that bed space.
I wish I could see my family.
You need a recess? No, we'll take a recess.
No, we're good. I wanted to see my family. I just had another stroke in here in jail, and I would really like to see my family. I just found out that my daughter is pregnant again with my second grandchild, and he's going to be born with Down syndrome. I messed up.
Do you want to go with the plea go ahead with the plea today, or do you want to wait for a couple of weeks? Do you want to go finish the plea today?
Let's finish the plea today.
Okay.
All right. You've signed all these plea documents. I've sworn you to the ones that are sworn to. We've been over it a couple of times, but, just sort of go back and be sure you understand your plea agreement is if you plead guilty, I'm going to withhold the finding of guilt. I'm going to assess you 3 years deferred adjudicated probation under your plea agreement. Your first condition will be that you'll be assigned to the Safe P program, and you have to successfully complete the Safe P program as a condition of your deferred adjudicated probation. We've been over that, and you understand that part.
Yes, sir.
These are the other documents. You've got an acknowledgement of admonishments. It gives you the full range of sentencing. If you do not successfully complete the deferred or you violate any condition of your deferred, the state will file a motion to adjudicate your case. And if the judge finds you have violated any of the condition, one of those conditions is you have to be successful in the Safe P program. If you get basically ejected from the Safe P program because you didn't successfully complete it, the state, Ms. Anderson, will use that to file a motion to adjudicate your case which can cause you to be found guilty because which can result in a violation by not completing Safe P successfully. The state will use it to adjudicate your case, ask a judge to go back and find you guilty. And if that happens, you can receive the maximum because it's deferred. Do you understand all that?
Yes, sir.
All right. So then there's a total of 7 admonishments. You and Mr. Robertson have signed below the 7th on their explanations. Do you understand all of them?
Yes, sir.
You understand you're waiving giving up your right to a trial by jury.
Yes, sir.
You're waiving confrontation with witnesses and agreeing to stipulate testimony. Do you understand that?
Yes, sir.
You signed and now sworn to a stipulation of evidence, which is a written judicial confession to the offense charged in the indictment. Do you understand that?
Yes, sir.
An agreement to stipulate testimony. There's a waiver form for a way you're waiving your right to appeal, waiving giving up your right to file a motion for new trial. Do you understand that?
Yes, sir.
You're waiving what we call a pre-sentence report, and I'll fill out a trial court certification of your rights to appeal. I'm going to follow the state's recommendation, your plea bargain. And so I'll check this is a plea bargain case and you have no right of appeal and that you've waived your right of appeal. Do you understand that?
Yes, sir.
All right. And there's an advice you've signed and now sworn to, an advice you've received from your attorney. Do you understand all those?
Yes, sir.
All right. Hang on just a minute. We'll start right back up as soon as I get back.
Mr. Robertson, can you call my family today if you don't mind, whenever you get done?
Yes, I will.
And ask my mom about my check to see if she can bring it to me so I can put it on my books for when I go.
I will.
Thank you. I need to see exactly how long. 9 months.
All right, going back and continuing on the record. I'm sorry, I had a warrant I had to talk to a trooper about.
It's okay.
We're continuing on the record in 24106-57-21 State versus Amy McKnight. We were, where'd I gotten to, Ms. Anderson?
We were right about for her to take her actual plea of guilty. You've done all the questions leading up to that.
All right. You do understand all the allegations, the charge in the indictment, the full range of sentencing, all your plea papers and your plea agreement. Is that correct?
Yes, sir.
All right. In cause number 24106-57-21, what is your plea date of the indictment charging you in possession of a controlled substance less than a gram?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way or promise you anything or coerce you to plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment as a result of any type of delusion in your mind or any type unrealistic hope of pardon, parole, or leniency?
No, sir.
Court does receive and accept your plea of guilty to the indictment. What do you have, Ms. Anderson?
We offer states 1, the plea packet with signed waivers and admonishments. States 2, the signed and sworn stipulation of evidence, as well as states 3, the discovery compliance documents.
No objection, Your Honor.
With no objection, the court admits into evidence states 1, all the plea documents signed or signed sworn to by the defendant, signed by her attorney, signs no state's attorney, all admitted in states 1, states 2, the signed sworn to stipulation of evidence, written judicial confession by the defendant to the allegations in the indictment. That's approved, admitted into evidence with no objection. States 2, states 3, discovery compliance approved by the court, admitted into evidence. Court does find the defendant's waiver of her rights and execution of all the other documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this case was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily, and fully supported by the evidence. However, the court does withhold a finding of guilt to the defendant, follows the plea agreement for recommendation of the state, processes the sentence at 3 years, deferred, adjudicated probation, withholding a finding of guilt. Courts considered under 1245, DA 2101435. In terms of the 3 years deferred adjudicated probation, the first condition of the deferred adjudicated probation assessed by the court will be that the defendant will be continued in custody of the sheriff until in jail until she can be transported to the Safe P facility. In its term and condition of her deferred adjudicated probation, she successfully complete the Safe P program in the Safe P lockdown facility as a term and condition of her deferred adjudicated probation. The other terms and conditions of deferred adjudicated probation will be explained to her by her supervising probation officer who's on the screen, or there's a probation officer on the screen.
Dean Morales.
Any legal reason, have I gotten a formal sentence and get it done? In this, the court does formally pronounce sentence, withholds the finding of guilt, places defendant, orders defendant on 3 years deferred adjudicated probation under all the terms and conditions normally assessed for this offense. The number one condition is that the defendant must the number one condition of the deferred adjudicated probation is the defendant must successfully complete the Safe P program as a condition of her deferred adjudicated probation. And she will remain in Smith County Jail under the standard procedures till she can be transported to the state Safe P facility to an opening. And then she has to complete the Safe P facility as a condition of her deferred. The number one condition, it is a lockdown facility. Sentence is formally pronounced, will be reflected in the judgment. Mr. Robeson, I have a waiver of appeal, waiving and giving up a right to appeal, and waiving filing a motion for new trial. Are those being presented to the court?
They are, Your Honor.
Okay, Ms. McNack, do you understand you're waiving your right to appeal and waiving your right to file a motion for new trial because I've followed the plea agreement?
Yes, sir.
All right, is there anything further? Are you satisfied with Mr. Robeson's legal representation?
Yes, sir.
All right, you'll be continued to the custody of the sheriff, Ms. McNaught, until you can be transported to an opening in the Safe P facility, which you're ordered to complete successfully is the number one condition of your deferred adjudicated probation. All right, we're in recess.
Could you tell me we need LaQuinn?
Yes, sir.
He responded once, he hasn't responded to the last one.
Well, think about it is, yeah, he does. Now, think about it is, he bring it up here, and I'll get Ms. Anderson to get ready to get it going up. Now I'll sign it.
And then I just told Bundy that's what he did.
Ms. Anderson, can you hear me?
Yes, sir.
This doesn't have anything to do with this case, but I just got a call from a trooper. Of course, I'm on blood draw duty, but the computer that does the standard blood draw warrants is obviously at my house. It's not down here, but he has a defendant up at the hospital, booked in in the hospital, and it's of a wreck, a crash. So he's got victims of the crash, and the trooper needs to come up. Sergeant Bundy is supposed to have told him that he needs to come up here because we can't do that one on the computer. It's a blood draw off a wreck. And so he's supposed to be coming up here, and I'm going to tell Denise, tell him to get with you to get the blood draw. He just needs a blood draw warrant. But what he needs, if he's sent it, it's at the computer at my house.
I see.
You follow me?
Yes, sir. If you want to send him up to my office, we can let him use one of the computers and help him up here. It's just that it is the middle of lunchtime. So if he rings the bell, I may have to get up from the hearing and go get him and come right back.
Yeah, you can do that because somebody is, I mean, he needs a blood draw out of a wreck. This is obvious, but the computer that minors are done on are because ordinarily if it's like this, they'll just send somebody with it, but the computer is out there because most of them we get are at night.
Well, you can send him up and we can see if we can help him out. I'll try to find somebody else on the floor here.
Yeah, why don't you do that? I believe Denise is getting him. She's told him, I believe, to contact Sergeant Bendy. She's text Sergeant Bendy, and they're supposed to be getting it handled.
Okay.
But it's just, we don't have the intoxication, manslaughter, or intoxicated assault. We can do a DWI, but this is an injured victim in a crash.
Sure.
So anyway.
Is he on his way up now?
Well, Denise talked to Sergeant Bundy because we're going to have to get Sergeant Bundy to get with him to explain what he needs to do. Why don't you call Sergeant Bundy?
Yes, sir. We've got it.
Have you got it?
Yes, sir. Just talked to Denise and we're all squared away and we can proceed.
All right, we'll get back on this. All right, we're on the record in cause number 2410881-20 State versus Quinn Williams on a motion to adjudicate guilt. She's present before the court with her attorney, Mr. Roberson from jail. Ms. Anderson is present for the state. You want to waive the reading and formal presentation of the motion to adjudicate guilt, Mr. Roberson?
You're muted, Clifton.
We waive the formal reading of the motion to adjudicate guilt. She knows what the allegations are, going in a plea of truth to all allegations, Your Honor. And also in paragraph 2, there's an allegation about a new offense for a theft misdemeanor. She's going to admit truth to that also, Judge. She's taking responsibility for that.
All right, Ms. Williams, raise your right hand. Solemnly swear your testimony will be the truth, the whole truth, nothing but the truth to help you God?
Yes, sir.
Have you gone over the state's motion to adjudicate guilt, which alleges violations of your deferred adjudicated probation with Mr. Robeson, your attorney, so you understand the allegations in all 9 paragraphs which allege violations by you of your deferred adjudicated probation?
Yes, sir.
Now, those are all set out in the motion to adjudicate guilt. And in addition to the motion to adjudicate guilt, filed September the 21st, 2021, I have now going up is the written plea admonishments and stipulations of evidence. The written plea admonishments and stipulations of evidence, that's stage 5. Let's see if we can get that up there. We still got the motion to adjudicate guilt up there. There you are. That's what we need right there. The written plea admonishments stipulations of evidence, states exhibit 5. Have you been over that with Mr. Roberson, your attorney, Ms. Williams, where he's explained it to you?
Yes, sir.
Do you understand the 4 admonishments, 1, 2, 3, and 4?
Yes, sir.
The second portion of the document tells me that you understand the admonishments and the allegations, and you make the following free, knowing, intelligent, and voluntary stipulations of evidence. You say the defendant whose signature appears below, being you and who is appearing by Zoom before the court, is the same person as originally placed on community supervision in this cause. I find that to be true. 2,
Yes.
you say that the allegations as set out in paragraphs, all the paragraphs of the state's motion to adjudicate guilt are true, and that you, with Mr. Roberson present, are entering pleas of truth to all the allegations in the state's motion to adjudicate, which allege violations of your deferred adjudicated probation in all 9 paragraphs. Is that correct?
Yes, sir.
Are you stipulating and entering those pleas of truth to all the paragraphs of the state's motion to adjudicate guilt freely, intelligently, knowingly, and voluntarily?
Yes, sir.
No one's coerced you or threatened you in any way or made you plead true. Is that correct?
No, sir.
The court receives and accepts your pleas of truth to all the paragraphs which allege violations in the motion to adjudicate. Are you offering in state's fine?
I am, Your Honor.
No objections.
No objection. States 5, the written plea admonishes stipulations of evidence signed by the defendant, sworn to by the defendant, signed by Mr. Roberson, approved by the court, admitted into evidence as State's Exhibit 5. The court having admitted into evidence State's Exhibit 5. And to be sure, Ms. Williams, I sort of got off on something else. You are solemnly swearing under oath that all of the statements in the written plea admonishments or stipulations of evidence signed by you and now sworn to by you are true and correct. Is that right?
Yes, sir.
All right, the court's approving states 5, signed, sworn to stipulations of evidence. Did you offer 5?
I did, Your Honor.
States 5 is admitted into evidence. Court having received and accepted defendant's stipulated and entered pleas of true, having to all the allegations of the state's motion to adjudicate, the court having approved, admitted into evidence, states 5, the written plea admonishes stipulations of evidence containing the stipulated pleas of true by the defendant to all the allegations in all the paragraphs of the state's motion to adjudicate guilt, which allege violations of her probation. The court does find all the allegations in the state's motion to adjudicate guilt alleging violations of the defendant's deferred adjudication probation to be true, based upon states 5, the written plea admonishes stipulation of evidence signed, sworn to by the defendant, signed by her attorney, which the court submitted into evidence, states 5. The court does grant the state's motion to adjudicate. The court does find the defendant guilty of the offense alleged against her by the state in its indictment. And the court assesses the sentence. What was the recommendation on this?
9 months, Your Honor.
Correct, Mr. Roberson?
It is correct, Your Honor.
Court having granted the state's motion to adjudicate, find all the allegations therein to be true. The court granting the state's motion to adjudicate, finds the defendant guilty of the offense alleged in the indictment. State jail felony, assesses the sentence. I'm sorry, Ms. Anderson, what was it?
Your Honor, 9 months state jail.
Assesses the sentence at 9 months in a state jail facility, assessed with credit for time served, restitution order to DPS for the lab fee analysis. Correct, Mr. Roberson?
Correct, Your Honor.
Like 9 months sentence is formally pronounced. It's assessed with credit for time served in the Smith County Jail. Waiver of appeal. You understand, Ms. Williams, you filed a waiver giving up your right to appeal, and a waiver giving up your right to file a motion for new trial back at the time I placed you on deferred adjudicated probation. You understand that?
Yes, sir.
Anything else, Ms. Anderson?
No, sir.
Anything else, Mr. Roberson?
No, Your Honor.
All right. Court, having granted the state's motion to adjudicate, court does find the defendant guilty of the offense alleged in the indictment, assesses the sentence pursuant to the agreement between the state and defense approved by the defendant, waiver of appeals accepted. if there's nothing further, we're in recess. The defendant is continued in custody until she can be transported to a state jail facility to discharge the sentence assessed by the court, to which she's agreed, her attorneys agreed, and recommended by the state. I believe I've asked you, Ms. Williams, are you satisfied with the legal representation of Mr. Clifton Roberson?
Yes, sir.
Okay, we're in recess.
Judge, I think we got 2 more pleas and they're out of jail.
Okay, Clifton, what are those gonna be? You gonna come over to court or what?
They on Zoom, Your Honor.
Okay. I'm gonna take about a 10-minute recess, wrap this other deal up, and I'll be back.
Yes, Your Honor.
Oh, sorry.
That's okay. They're gonna be off somewhere else.
Yes.
You said you got another one?
Yes.
Okay, they're all somewhere else.
Ms. Bircher? Can you hear me?
He is in.
Angela, can you hear me?
Yeah, that's the same model.
Angela, can you hear?
Sounds like
Yeah.
All right, Clifton, we'll reset her for another day
In person.
in person.
Okay, I'll let her know. I'll get ready to call her.
Okay, thanks.
All right, see if you can get Miss Whitney.
Yeah, I'm trying to get her logged back in.
This crash happened.
Hey, Tabitha.
We may have to reset Whitney as well.
Okay, well, I just got the phone with her. I told Angela to go to work. Okay. You want to just tell Whitney, wait till we go to court to have her in there too?
Well, she's trying to log in, but it's not connecting. So I think she's having internet issues.
Well, let me give her a call. Let me just do this. Let me just get her reset for court too.
Okay.
Well, I'm giving her a call.
All right. Sounds good. Thank you, Clifton.
Hey, Tabitha.
Yes.
Okay, what time are we going to start?
If you have problems, we're just gonna reset you for another day so we can go in court in person, okay?
1:30, Elizabeth.
Well, they can't pick you up.
Okay.
So we're just gonna get you reset to when we can